Bismillah ar-Rahman ar-Rahim. Assalamu alaikum wa rahmatullahi wa barakatuh. Introduction to Paralegalism, Perspectives, Problems, and Skills. 9th edition. Chapter 12, narrated by Omar Mohsen Ibrahim Fouad. Chapter 12, Legal Interviewing. Chapter Introduction. Chapter Objectives. After completing this chapter, you should be able to identify the skills needed to interview a client, explain a typical attorney-client fee arrangement, explain a typical attorney-client fee agreement, describe the role of interviewing in litigation, outline what is included in an intake memo, list guides for the formulation of interview questions, and provide examples of interview questions. Critique the dangers of your own bias in the interview process. Enumerate ways to prepare for and begin an interview. Explain the techniques of attentive listening and achieving comprehensiveness in an interview. List the dangers of ethical violations in interviews and how to avoid them. Identify examples of difficult clients and how to manage them. What if your attorney has asked you to interview a potential client in a products liability case where all you know is that the person had severe damages to their upper body, including their face? Unfortunately, your supervising attorney had a personal emergency and wants to keep the client's appointment, believing this could be a real money-making case. You reluctantly agree to do the interview, even though you have never formally interviewed someone on your own. Although you have sat in on many interviews over the years, you keep telling yourself to just get the facts of the case, presenting them to the attorney. You keep telling yourself to just get the facts of the case, present them to the attorney, and that will be that. Not knowing what to expect, you attempt to prepare the conference room for the interview. When the client arrives, they are wheelchair bound and have a caregiver. Escorting the client and caregiver back to the conference room, the potential client asks where the attorney is, and you professionally explain the emergency and see the client's demeanor change, visibly growing angry, wanting to know why the matter was not rescheduled. The client begins to leave, saying under their breath that they will be seeking the assistance of another law firm. But you assure the client that you have done this before, and you suggest that since they made the journey to the office, that they might discuss some of the general information about the case. You encourage the client to stay and begin the interview. The new client sees that the paralegal prepared the conference room with coffee and refreshments. Accepting some coffee and fruit, they state that they will stay a bit. You begin getting the general information and together work through some of the documents about his case. During the interview, the client grows agitated and starts raising their voice at you. You are not sure what to do and don't want the client to leave. What is the best way to handle the situation? Client interviewing is one of the important skills needed to learn in becoming a paralegal. Part of learning the interview process is also learning to manage all different types of clients. As this chapter will illustrate, using your prowess and skills in managing and maintaining client relationships is an important part of a paralegal's function. As we proceed through the chapter, facts such as those in the beginning are just a sampling of the situations in a paralegal. As we proceed through the chapter, facts such as those in the beginning are just a sampling of the situations a paralegal may encounter when interviewing a client. Knowing how to prepare for the interview, identifying the questions to ask, and maintaining professionalism are the skills necessary to the successful handling of all kinds of clients, from the interview stage and beyond. That will be the focus of this chapter. (12-1) Introduction. Whether you'll be interviewing clients as a paralegal often depends on the type of practice in which you are involved. Paralegals often interview in the following. Whether you'll be interviewing clients as a paralegal often depends on the type of practice in which you are involved. Paralegals often interview in the following. High-volume law offices where the office handles many of the same kind of case, like for example, automobile, negligence, collections, bankruptcy, or DWI, driving while intoxicated. An office bringing a class action in which there may be numerous clients or potential clients. Think of the movie Erin Brockovich. Legal aid offices that provide free legal services to people with low income, or government agencies that have extensive interaction with the public. In most other offices, however, paralegals are more likely to do occasional follow-up interviews after the attorney has conducted the main interview. Nevertheless, all paralegals should know the dynamics of the interview process in order to increase their understanding of the overall practice of law and to be ready for the time when they are called on to conduct a legal interview. Paralegal Chris Baker was glad she was ready when her supervisor supervised. Paralegal Chris Baker was glad she was ready when her supervisor surprised her with an unusual assignment. Interview all the players on a women's high school basketball team. Interview all the players on a women's high school basketball team about whether their coach had inappropriate contact with them. (12-2) Professionalism, your calling card. Some clients you will be working with may be hiring an attorney for the first time. Their image of the legal profession is often heavily influenced by the portrayal of attorneys in the media. Attorneys are perceived in different ways, some positive and others negative. We do our best to combat the negative images by exhibiting characteristics that show empathy, professionalism, and skills. How clients perceive you matters a great deal. The way you dress, how you communicate, and how you perform your job can reinforce the positive image we all want to portray and diminish any negative perceptions that some may have of the legal profession. Whether you are interviewing the client, relaying a message to or from a client, or have roles that require no client contact, it is extremely important that you project yourself as a professional. There is no better way to combat negative perceptions of attorneys than for everyone in the office to maintain a high level of integrity and competence. You should act on the assumption that every large or small task you perform on a client's case is of critical importance. Even if you have only a small role in a particular client's case, you should assume that how you perform your role will help determine whether the client is satisfied with the services rendered by the entire office and whether they will readily recommend the office to relatives, friends, and business associates. Admittedly, you cannot single-handedly correct the public's perception of attorneys. To a significant extent, the public does not have a clear understanding of the role of attorneys in society, but you can exude the professionalism that makes us stand out and show why we are who we are, and by our actions exhibit the professionalism that makes clients want to embrace us and our roles. As our Constitution guarantees, everyone is entitled to their day in court. The legal system would collapse if attorneys refused to represent anyone who was not clearly innocent. Attorneys sometimes take unpopular cases such as defending people charged with committing heinous crimes, such as the murder case involving the Idaho students. When interviewed on TV or radio, these attorneys seldom generate much sympathy. Attorneys are frequently injected into the middle of bitter disputes where they become lightning rods for underlying and overt hostility. Opponents often accuse the other attorney of causing the hostility or of setting up roadblocks to resolution in order to increase fees. Opponents often accuse the attorney of causing the hostility or of setting up roadblocks to resolution in order to increase fees. Although you cannot eliminate these perceptions, you can perform your job in such a way that the client feels that their case is the most important case you are working on, and that you are doing everything possible to help the office keep costs to a minimum and make them a priority. This kind of professionalism will be a significant step in the right direction and enhance clients' perceptions about the practice of law. 12-3 Hiring the firm. As we saw in Chapter 6, there are several ways in which an attorney-client relationship is created and formalized. The main way is by signing an attorney-client fee contract. See Exhibit 12-1. This is also called a retainer agreement. The document covers the scope of services to be provided as well as the payments the client will be making for those services. The payments will be for attorney's fees, paralegal fees, court costs, like for example filing fees, and any other expenses, like for example witness fees and travel costs, that may be involved in the representation. The noun retainer has several meanings. It is the act of hiring or engaging the services of someone, usually a professional. The verb is retain. Retainer also refers to the amount of money or other property paid by a client as a deposit or advance against future fees, costs, and expenses of providing services. Exhibit 12-1, example of an attorney-client fee contract. Attorney-client relationship might also be formalized by an engagement letter that specifies the scope of the professional services to be rendered. At the end of the letter, there is space for the prospective client to sign, indicating agreement with the terms stated in the letter. Suppose, however, the attorney decides not to accept the case. This may happen for a number of reasons. There may be a conflict of interest because the law office once represented the opponent of the prospective client. Refer to Chapter 6. The attorney may feel that the case lacks merit because there is no legal justification for what the client wants to accomplish. More commonly, the attorney will refuse to take the case for economic reasons. The client may not be able to afford the anticipated legal fees, and the party the client wants to sue may not have enough cash or other resources to pay winning judgment. Such an opponent is said to lack a deep pocket. Whatever the reason, it is important for the office to document its rejection of prospective clients by sending them a letter explicitly stating that the office will not be representing them. The document is called a letter of non-engagement or a declination letter. Its purpose is to avoid any misunderstandings if the person later claims to have been confused about whether the office had agreed to take the case. This person may try to assert that they took no further action on the case because of the belief that the office was going to provide representation. The ultimate nightmare occurs when this person loses the case by default because no one showed up in court at a scheduled hearing and the statute of limitations ran out before any action was taken to bring the claim. The attorney may now face a legal malpractice lawsuit based on the person's reasonable assumption that the attorney was going to pursue the case. One way to avoid this predicament is by sending prospective clients an empathetic letter of non-engagement. The letter will often conclude with a statement such as the following: although our office cannot represent you, we urge you to protect your rights by seeking other counsel. Quick tip: a paralegal can present a fee agreement for signature to a client, but cannot discuss fees with the client. The attorney must do that. Analyze this. Find examples of a retainer agreement for a personal injury, collection, and general corporate representation. Identify the different provisions and obligations in these types of retainer agreements. Are the fee structures the same? If not, what are the differences? (12-4) Context of interviewing and litigation. There are three main kinds of legal interviews: initial client interview, follow-up client interview, field interview of someone other than the client. In the initial client interview, the attorney-client relationship is formally established and legal problems are identified as the fast collection process begins. Follow-up interviews occur after the initial interview. The client is asked about additional facts and is consulted on a variety of matters that require attention, consent, or other participation. The field interview is conducted during investigation. The interviewer, as investigator, will contact individuals outside the office in order to try to verify facts already known and to uncover new relevant facts. Investigation will be examined in the next chapter. Here our focus will be the initial and follow-up client interviews. Interviewing is among the most important skills in a law office. Many assume that the skill is relatively easy to perform. All you need is a person to interview, the interviewee, a pleasing personality, and some time. Yet interviewing is much more than good conversation. To avoid incomplete, and sloppy interviewing. The interviewer must establish a relationship with the client that is warm, trusting, professional, and goal oriented as the office goes about its mission of identifying and solving legal problems. The materials in this chapter, particularly the charts and checklists, are designed to help you achieve this relationship. The initial client interview is critical because it sets the foundation for the entire litigation process. See Exhibit 12-2. The facts obtained from this interview are further pursued through field investigation. Subsequent or follow-up interviews are often needed to clarify new facts and pursue leads uncovered during investigation. The laws governing the facts are researched online in a traditional law library or both. The facts and the governing law are informally argued between counsel for the parties in an effort to settle the case through negotiation. If there is no settlement, a trial is held in which the facts are formally established. Finally, the process may end with one or more appeals. Everything begins with the facts obtained through the initial client interview. A poor job done at this stage can have major negative consequences throughout the remaining steps of the litigation. Exhibit 12-2, interviewing process in the litigation context. Appeal, trial, negotiations for settlement, legal research, follow-up interviews, field investigations, initial client interview. Initial client interview, field investigation, follow-up interviews, legal research, negotiations for settlement, trial, appeal. Indeed, the initial client interview and engagement is critical. It should have the participation of an attorney. Unfortunately, for a paralegal in Ohio, he thought he could mask the fact that he was a paralegal by stating the supervising attorney had died and thus was not violating the law when he interviewed, discussed fees, and engaged and even advised on the law. The Ohio Supreme Court took action in Cleveland Metro Bar Association v. Davey 133 Ohio State 3D 202 977 NE 2D 606 Ohio 2012. Order of the Court, a case study, Cleveland Metro Bar Association v. Davey, Supreme Court of Ohio, 133 Ohio Street, 3D 202 977 NE 2D 606 Ohio 2012. Davey is an interesting case as it involves a paralegal who was a convicted felon who earned a paralegal certificate while incarcerated. After serving 14 years of his sentence, he formed ALS INC and began his legal career. The subject of this case involves 3 matters in which Davey acted as a paralegal without true supervision of an attorney, contrary to his representations. Davey first was hired to represent an inmate in a motion to suppress, where he executed a retainer agreement, interviewed the client, performed legal research, and prepared and filed a motion to suppress. Even though the client was represented by a public defender, Davey claimed he was hired and that his work was supervised by an attorney, Sebrayan Haygood, who had died. In testimony at a disciplinary hearing, Davey admitted that Haygood never met the inmate or communicated with him or had any contact with him regarding his case. Any documentation that showed he was supervised had been lost. The inmate refused to pay him. Davey filed a court action for the fee and won. The second matter involved a custody matter. The client, the Singletons, signed an agreement for his signed an agreement for his representation and stated that the work would be supervised by an attorney, even though none was named. Eventually, the Singletons could not pay their fees. Davy sued them and won. The third case involved a parole hearing. Davy filed a memorandum in support of inmate Jones's request for release on parole. In that matter, Davy once again claimed that he was not an attorney and was supervised. The court reviewed all the evidence and testimony before it. It discussed the definition of attorney and what constitutes the authorized practice of law. The court then discussed Davy's representation of Jones. Apparently, they had met in prison. Even though the court found that Davy used his paralegal registration from Ohio and did not use Esquire after his name, the document he prepared for Jones gave the impression that he was an attorney and his representation of Jones at the parole hearing. Although the court acknowledged that lay people can and do come before the board to represent inmates. Davy's venturing into the use of legal arguments and citation of cases crossed over to the unauthorized practice of law. Here the court deemed it important to protect the public interest and scrutinized Davy's conduct and actions, which is why they found that he did engage in the unauthorized practice of law, for which he was sanctioned. As for the motion to suppress matter and the custody dispute, the court also found that Davy contracted with clients for his legal services and that his actions were the unauthorized practice of law, as he was not supervised by an attorney and provided no evidence of that supervision. Based on the violations, the court imposed sanctions. One of the main reasons for the imposition of the sanctions was because of the flagrant disregard for the law that Davy had and how his action affected the public confidence. Discussion questions. Review Cleveland Metro Bar Association versus Davy. Who were the parties to the case? What were the initial findings of the panel, and were they followed by the court? What was the reasoning behind the court's findings? What were the sanctions imposed and why? Was the result in the Davy matter just and appropriate? 12-5. Format of an intake memo. Before analyzing the interview process, we should look briefly at one of the end products of the interview, a document that is sometimes called the intake memo. It contains the facts given by a client during the initial client interview and comments by the interviewer about the client and the case. The intake memo becomes part of a newly opened case file on the client. The memo often has 5 parts. 1. Heading. The heading provides the following information at the top of the first page. The title of the document, here, intake memo, centered at the top of the page. The supervisor in charge of the case to whom the memo is addressed. The name of the person who wrote the memo, the date the memo was completed and submitted, the date the interview was conducted, the name of the case, client's name and opponent, if any, the office file number of the case, the internal numbering and or lettering, system used by the office to identify files of its clients. The kind of case, general area of the law covered in the interview, like for example, mortgage, foreclosure, child custody. The notation RE, which means concerning, in the matter of, or in reference to. After RE, provide a brief overview of what is covered in the memo. 2. Personal data, name of the client, home address, mailing address, if different from residence, phone numbers where the client can be reached, email addresses, age of client, marital status, address of employment, etc. 3. Statement of assignment. The first paragraph of the memo should state the precise objective the paralegal was given in conducting the interview. It is a more detailed statement of what was listed under RE in the heading. 4. Body of memo. Here, the facts are presented in a coherent, readable manner according to a number of possible organizational principles. A chronological listing of the facts so that the events are unfolded as a story with a beginning, middle, and end. A categorizing of the facts according to the major topics or issues of the case, like, for example, background, accident, causation, and medical expenses, each with its own subject heading under which the relevant facts are placed. Any other format called for by the supervisor. 5. Conclusion. Here, different kinds of information could be included. Examples: the paralegal's impressions of the client's personality and the facts presented during the interview, such as how knowledgeable the client appeared to be, how believable the client appeared to be, a list of the next steps, such as what further facts should be sought through investigation, what legal research should be undertaken, other recommendations on what should be done on the case based on what was learned during the interview, a list of anything the paralegal told the client to do, such as bring in specified documents relevant to the case, check on further facts, and call back, return for another interview. Exhibit 12-3 shows a sample of the introductory parts of an intake memo. Exhibit 12-3, beginning of an intake memo. Twelve 6. What facts do you seek? Guides to the formulation of questions. Unless you know what to accomplish in an interview, valuable time will be wasted. For example, suppose you are interviewing a client on the grounds for divorce. You do not simply write down all the facts about the marriage and the client's problems in it. The facts must be clustered or arranged in categories that are relevant to each element of the grounds for divorce. Unless you have this objective in mind before and during the interview, you can end up with a confusing collection of facts and may have to conduct a second interview to go over matters that should have been covered initially. As all-star Yankee catcher Yogi Berra once said, if you don't know where you are going, you might wind up someplace else. This does not mean that the interview process must avoid any topic that is not directly related to the objective, but it does mean that each interview must have a definite focus. There are 6 major ways to achieve focus in the formulation of questions to be asked if a client, instructions of the supervisor for the interview. There are 6 major ways to achieve focus in the formulation of questions to be asked of a client. instructions of the supervisor for the interview, evidence, procedural law, and substantive law, checklists, fact particularization, FP, common sense, flexibility. These methods overlap at various times during an interview. You may be using all 6. The goal of the methods is to help you avoid all the following examples of ineffective. The goal of the methods is to help you avoid all of the following examples of an ineffective interview. You failed to seek the information that the supervisor wanted you to obtain. You missed major relevant facts. You failed to probe for greater details about unpleasant or unflattering facts that the client glossed over or avoided. You failed to ask questions about the extent to which the client was sure or unsure about the major facts the client gives you. You failed to pursue leads the client provides about other relevant topics that may not have been part of the supervisor's explicit instructions or may not have been within the scope of your initial questions. 12-6A Instructional 12-6A Instructions of the supervisor for the interview. The instructions of the supervisor control what you do in the interview. You may be asked to do a limited interview or a comprehensive one. Be sure to write down what the supervisor wants from the interview and include those instructions at the beginning of your intake memo. If possible, try to sit in on an interview conducted by your supervisor to observe their method of questioning and the amount of detail sought. Also examine some closed or open case files that contain intake memos. Ask the supervisor if any of these memos is exemplary, and if so, why. A factually detailed memo can be useful as a guide. Later in Exhibit 12-8, we will cover more of these preparatory steps. 12-6B Evidence, Procedural Law, and Substantive Law. Paralegal Sally Kane points out that fact gathering in interviewing and investigation should always be guided by the legal theories of the case and the facts and evidence you will need to support them. You do not have to be experts in every area of the law or in any particular area of the law in order to conduct an interview. At the very least, however, you should have a general understanding of evidence and civil procedure, or if the case is a criminal case, evidence and criminal procedure. You should understand the basic procedural steps in litigation in order to see how facts can be used in different ways at different steps in the litigation process. Also, you should have a general understanding of the substantive law that will be involved. In this regard, it would be sufficient to know what the basic cause of action and defenses are likely to be. We will cover evidence in Chapter 13 and provide an overview of civil and criminal We will cover evidence in Chapter 13 and provide an overview of civil and criminal litigation in Chapter 14. Regarding the substantive law involved in the interview, you can obtain a quick overview of any area of the law online. Suppose, for example, you wanted to find the basic terminology, causes of action, and defenses for an automobile negligence case. You could search automobile negligence law AA, substituting the name of your state for AA. Many of the sites from this search will be attorney ads, but even the ad sites may provide useful overviews, as we saw in Chapter 9. An office would not rely on such overviews in a memorandum of law or appellate brief. Overviews of the law found online are no more than starting points. On assessing the reliability of the law online, see Chapter 9. Analyze this. Using our facts from the beginning of the chapter and relying on the skills from legal analysis and research, what areas of the law should you, what areas of the law should you have reviewed before meeting with the client? Use the techniques from Chapter 9 on legal research to begin this process. 12-6C. Checklists. The office where you work may have checklists that are used in conducting interviews for some kinds of cases, such as probate or bankruptcy. The checklists may be extensive. If such checklists are not available, you should consider writing your own for the kinds of cases in which you require experience. Caution is needed, however, in using checklists. You should find out why individual questions were inserted in the checklist. You should be flexible enough to ask relevant questions that may not be on the checklist. You should be open to questions not on the list, such as follow-up questions based on the information provided by the client. By definition, a checklist is nothing more than a standard form. Use it as a guide that must be adapted to the case and client in front of you, rather than a rigid formula from where there can be no deviation. Use it as a guide that must be adapted to the case and client in front of you, rather than as a rigid formula from which there can be no deviation. There is a danger of being so tied to a checklist that you fail to hear and respond to what the client is saying. Online exercise. Search online for a case checklist for the product's liability case with an airbag issue. Think of the facts in the chapter introduction. A negligence case for a slip and fall and a civil rights case on age discrimination. Place the checklists in your portfolio binder. (12-6D). Fact particularization. How much detail should you try to obtain in an interview? Attorneys like facts. During 3 years of law school, they were constantly asked by their law professors, "What are the facts?" The likelihood is that the attorney for whom you work will want considerable detail from the interview, even if you are told to limit yourself to obtaining the basic facts from the client. You may find that the supervisor wants a lot of detail about those basic facts. When in doubt, the safest course is to be detailed in your questioning. Fact particularization, FP, is a skill that will help you obtain factual details. To particularize a fact means to ask an extensive series of questions about that fact in order to explore its uniqueness. Fact assessment is critical to the practice of law. FP is critical to the identification of the facts that must be assessed. FP is a fast collection technique. It is the process of viewing every person, thing, or event as unique, different from every other person, thing, or event. Each important fact that a client tells you in an interview should be particularized. Each important fact a client tells you in an interview should be particularized. You do this by asking a large number of initial and follow-up questions. Who, what, where, how, why. Who, what, where, how, when, and why. Once you have targeted the fact you want to explore, see Exhibit 12-4. Exhibit 12-4. Fact particularization, FP. To particularize a fact you already have, assume that what you know about this fact is woefully inadequate. Assume that there is more than one version of this fact. Ask a large number of who, what, where, how, when, and why questions about the fact, which, if answered, will provide a specific and as comprehensive a picture of that fact as is possible at this time. The questions do not have to be asked in any set order, so long as the multiple questions are asked for each fact connected to the case. FP can be a guide in formulating factual questions that need to be asked in different settings. In a client interview, our focus in this chapter. In investigations, see Chapter 13. In interrogations, ROGS. During discovery, see Chapter 14. In a deposition, during discovery, see Chapter 14. In an administrative or court hearing, in which witnesses are formally questioned, see Chapters 14 and 15. Example of FP. You are working on an automobile negligence case. 2 cars collide on a 2-lane street. They were driven by Suki Hauser and Ed Jones. Jones is a client of your law office. One of the facts alleged by Jones is that Hauser's car veered into Jones's lane moments before the collision. Your job is to particularize this fact by trying to obtain a much more detailed picture of the alleged veering. This is done by seeking a comprehensive elaboration of this fact. Using FP, here are examples of common sense who, what, where, how, when, why questions you could ask to particularize the fact of veering. What does Jones mean by veered into the lane? How much veering was done? An inch, a foot? Did the entire car come into the other lane? How much of an angle was there? Who saw this happen? According to Jones, Hauser's car veered. Did Jones see this happen himself? Who else saw it, if anyone? Any passengers in Jones's car? Any passengers in Hauser's car? Were there any bystanders? Has the neighborhood been checked for witnesses? Like for example, people who live or work in the area, or people who frequently sit on public benches in the area. Were the police called after the accident? If so, who was the officer? Was a report made? If so, what does it say, if anything, about the car veering into the other lane? Where is this report? How can you obtain a copy? What time of day did the incident occur? What time of day did the accident occur? Why did Hauser's car veer according to Jones or anyone else who alleges that this occurred? How fast was Jones's car going at the time of the veering? Why was Jones going at this speed? Who would be able to substantiate the speed? Who might have different views of how fast Jones was going? How fast was Hauser's car going at the time of the veering? Why was Hauser going at this speed? Who would be able to substantiate the speed? Who might have different views of how fast Hauser was going? Have there been other accidents in the area? If so, how similar have they been to this one? What was the condition of the road at the time Hauser started to veer? At the time of the collision? What was the weather at the time? How was visibility? What kind of a road is it? Straight, curved at the area of the collision? Any inclines? Any hills that could affect speed and visibility? What kind of area is it? Residential? Commercial? Is there anything in the area that would distract drivers, like for example, potholes? Where is the nearest traffic light, stop sign, or other traffic signal? Prepare a diagram or obtain an online street map, like for example, through maps.google.com or mapquest.com, on which you note their location. How, if at all, did they affect traffic at the time of the accident? What is the speed limit in the area? What kind of car was Hauser driving? Were there any mechanical problems with the car? Would these problems have helped cause the veering? What prior accidents has Hauser had, if any? What kind of car was Jones driving? Were there any mechanical problems with the car? What prior accidents has Jones had, if any? Etc. Of course, the interviewee may not have the answers to all of such questions. The job of the interviewer, however, is to probe. You can't know in advance what questions will or will not be productive. In legal interviewing, the starting point for the FP process is an important fact, for that the client has told you during the interview. Here are additional examples. I tried to find work. The car hit me from the rear. The pain was unbearable. The company was falling apart. He told me I would get the ranch when he died. He fired me because I am a woman. With these starting points, you then ask the client the basic who, what, where, how, when, why questions that we used in the Hauser and Jones driving example. As a guide to help you organize these questions, Exhibit 12-5 presents 8 categories of questions and aids that can be asked in order to achieve competent FP. Fact particularization. Exhibit 12-5, categories of questions and aids for fact particularization, FP. Fact particularization. Steps. Begin by obtaining a general picture of what happened. Next, particularize every important fact you obtain by seeking comprehensive details on that fact through who, what, where, how, when, why questions that are relevant to the following interrelated categories. The fact to be particularized. Miscellaneous detail, analogies, observed facts and interferences, observed facts and inferences, place and environment details, date and time details, details on other participants, verification details, visual demonstrations. All 8 categories are not necessarily applicable to every fact that you particularize. Again, the questions need not to be asked in any prescribed order as long as you are comprehensive in your search for factual detail. The point of FP is to get the wheels of your mind rolling so that you will think of a large number of questions and thereby avoid conducting a superficial interview. Date and time details. When did the fact occur or happen? Find out the precise date and time. The interviewer should be scrupulous about all dates and times. If more than one event is involved, ask questions about the dates and times of each. If the client is not sure, ask questions to help jog the memory, and ask the client to check their records or to contact other individuals who might know. Don't be satisfied with the answers such as, "It happened about 2 months ago." If this is what the client says, record it in your notes, but then probe further. Show the client a calendar and ask about other events going on at the same time in an effort to in an effort to them be more precise. Show the client a calendar and ask about other events going on at the same time in an effort to them be more precise. Place and environment details. Be equally scrupulous about geography. Where did the event occur? Where was the thing or object in question? Where was the client at the time? Ask the client to describe the surroundings. Ask questions with such care that you obtain a verbal photograph of the scene. If relevant, ask the question to approximate distances between important objects or persons. You might want to have the client draw a diagram, or you can draw a diagram on the basis of what you have been told and ask the client if the drawing is accurate. Also, consider printing one of the online maps mentioned earlier. Ask questions about the weather or about lighting conditions. You want to know as much as you can about the environment or whatever the client could observe about the environment through the senses of sight, hearing, smell, and touch. Details on other participants. Who else was involved? Ask questions about who they were, their roles, their ages, appearances, etc. If relevant, where were they at the time? Where did they act? Why did they act? Why did they fail to act? Could you have anticipated what they did or failed to do? Why or why not? Have they ever acted or failed to act in this way before? Ask questions designed to obtain a detailed picture of who these other participants were and their precise relationship to the fact being particularized. Observed facts and inferences. Interviewers must also carefully distinguish between observed facts and inferences of fact. Observed facts are what the client directly experienced through the senses. Like, for example, I saw the car weaving back and forth over the center line. I smelled alcohol on their breath. An inference is a deduction or conclusion from facts. Like, for example, they were driving carelessly, they were drunk. Part of being comprehensive in an interview is to uncover all the observed facts that led to the inferences made by a client. This is not always easy to do. Opinionated clients sometimes confuse facts and opinions. They may state an opinion, but think it is a fact because they swear it is true. But opinions are merely inferences. Let a client express them during an interview and record them in your notes. But follow up with probing questions that identify underlying observed data. All of the categories of fact particularization will help you achieve. All of the categories of fact particularization will help you achieve this goal. Verification details. The fact that the client tells you something happened is some evidence that it happened. Verification details are additional evidence that supports what the client has said. Always pursue verification details. Ask yourself how you would establish the truth of what the client has said if the client suddenly disappeared and you had to rely exclusively on other sources. Inquire about documents such as letters or check stubs that support the client's statements. Inquire about other people who might be available to provide confirmation. Asking the client for verification details does not mean that you distrust the client or that you think the client is lying. It is simply a good practice to view a fact from many perspectives. You are always seeking the strongest case possible. This calls for probing questions about verification details. Analogies. Some facts you are particularizing are difficult to pin down. Like, for example, the pain was unbearable. I was careful. It looked awful. I was scared. In the interview, you should ask the client to explain such statements. Sometimes it is helpful to ask the client to use analogies to describe what is meant. When you ask clients to use an analogy, you are asking them to explain something by comparing it to something else. For example, what would you compare it to? Was it similar to anything you have ever seen before? Have you observed anyone else doing the same thing? Have you ever been in a similar situation? Did it feel like a dentist's drill? On a scale of 1 to 10, with 10 being the worst pain you have ever experienced, what number would you use to describe the pain? First, you ask the client to compare the fact to something else. Then you ask about the similarities and differences through a series of direct questions. You are encouraging the client to analogize. Through a series of direct questions, you are encouraging the client to analogize the fact to some other fact. This is done in a further attempt to obtain a comprehensive. This is done in a further attempt to obtain as comprehensive a factual picture as possible. Visual demonstrations under place and environment details. We mentioned the use of diagrams and maps as aids. Other visuals should also be considered. Creative interviewers realize that a brief demonstration, drawing, or exhibit can sometimes be effective in eliciting greater factual detail. One interviewer who works on many automobile negligence cases has a set of toy cars at their desk. Occasionally, they will line them up on the desk and ask the client to explain what happened by using the toy cars. People love visual demonstrations, as powerful as words can be. Charts, maps, graphs, reenactments, diagrams, timelines, and other visual aids can be very effective in communicating information. Drawing a timeline can be helpful when a story involves some complexity. The simplest format of a timeline is a straight line that lists significant events chronologically along the line. Each event might be drawn with a separate box that includes the date when the event occurred. See Exhibit 12-6. During an interview, draw a rough sketch of a timeline based on the facts given to you and show it to the client. A diagram such as this gives the client a visual overview of what occurred and may prompt further questions and clarifications. Exhibit 12-6, example of a timeline. Miscellaneous details. Here you ask about any details that were not covered in the previous categories of questions. Include questions on anything else that might help in particularizing the fact under examination. Follow-up is important, particularly when facts are mentioned by the client. Try and do the follow-up immediately so that neither the client nor you will forget the particulars of the facts discussed. Let's think about our facts. From the introduction, you observe that the client has injuries that affect his upper body. You should start with a general question such as, paralegal, so Mr. Eliason can tell you, can you tell me a little bit about why you came here today? Client, isn't it obvious? I was injured when an airbag exploded in my face while I was driving my SUV. Paralegal, what type of SUV were you driving? Client, a Honda. Paralegal, in the year of the SUV? Client, 2018. Paralegal, what was the model of the Honda SUV? Client, a Honda Pilot. Paralegal, Now, let's get some more details. Tell me exactly what happened when the airbag exploded. Client: I was driving down the road and hit my brakes as I thought I saw a deer. Right after I hit the brakes, the airbag came out, hit my face, and made me hit a tree. As our facts are starting to reveal, we see that an airbag improperly deployed when the brakes were applied, causing Mr. Eliasson to lose control of the car and hit a tree. We are slowly developing the facts and also trying to gain the client's confidence while asking the questions. Know that you will have to engage and follow up with your questions so that you gain as much information about the case as possible. Analyze this. Returning to our facts in the introduction of the chapter, and as we see, returning to our facts in the introduction of the chapter, and as we learned within the chapter, the client had an airbag injury. Prepare the list of questions eliciting 1. Date and time details, 2. Place and environment details, 3. Details on other participants, and 4. Observed facts and inferences. 12-6E. Extent of certainty and uncertainty. Everything the client tells you can be placed somewhere on the spectrum of uncertainty. Everything the client tells you can be placed somewhere on the spectrum of certainty. See Exhibit 12-7. It would be a mistake, for example, to record that the client said a letter was received 2 weeks ago, when in fact the client said, I think it came 2 weeks ago. Do not turn uncertainty into certainty by sloppy listening and sloppy recording in your notes and intake memo of what the client said. Of course, it may be possible for a client to be uncertain about a fact initially, but then become more certain of it with the help of your questioning. If so, record this transition by saying, the client at first did not remember who else was present, but then said they thought Fred was probably there. Exhibit 12-7, Spectrum of Uncertainty. Exhibit 12-7, Spectrum of Certainty. As a client answers questions, make note of how certain the client is of each answer. Where on the spectrum does the answer fit? Absolutely certain, substantially certain, fairly certain, have a vague certainty, unsure, only a guess. At the outset, explain to the client how critical it is for you to obtain accurate information. Encourage the client to say, I'm not sure. When that is the case, a client may not want to be hesitant about facts that are favorable to what they are trying to accomplish. Clients must be relaxed and unthreatened before they will be honest and frank about what they know and equally important about what they do not know. A lot depends on the attitude of the interviewer in asking questions and in reacting to answers. Let the clients know that when you ask a question, you are looking for no more than the best of their recollection. Never be irritated or disappointed when a client cannot answer a question with absolute certainty. Do not keep saying, are you sure? After every client answer. Probing will be often necessary in order to find out where on the spectrum of certainty a fact falls. Yet probing must be undertaken with sensitivity. Repeating what the client has said in the form of a question can be a tactful way to reinforce the importance of obtaining precise dates and times. Like, for example, you said the delivery was made at 1:30 in the afternoon. Do I have that right? We will cover similar interviewing techniques later in the chapter on attentive listening. 12-6F, Common Sense and Flexibility. Thus far, we have examined a number of guides for formulating questions, like, for example, checklists and fact particularization, in order to achieve comprehensiveness and focus. Common sense is another guide, although law has its share of legalisms and technicalities. The related traits of good judgment and common sense are still at the core of the practice of law. It is common sense, for example, to organize an interview by having the client tell the relevant events chronologically in the form of a story with a beginning, middle, and end. It is common sense to ask further questions that follow up on a potentially important topic the client mentions, even though you had not anticipated the topic. If the client says something you do not understand, common sense dictates that you ask what the client means before continuing with the interview. At times, it may be common sense to stop the interview for a moment to obtain further guidance from your supervisor. The best frame of mind an interviewer can have is to be prepared, but to be flexible enough to expect the unexpected. Although you led the interview and give it direction, you must be ready to go where the interview takes you. It could be a serious mistake to block out topics that arise solely because they were not part of your game plan in conducting the interview or are not on your checklist. As with so many areas of law, you may not know what you are looking for until you find it. In interviewing a client about incorporating a business, for example, you may stumble across a lead from something the client says that could involve fraud or criminal prosecution on a matter unrelated to the incorporation. Don't block this out. Make note of it for further questions later and for further instructions from your supervisor. 12-7. What does the client want? Recently, a veteran paralegal reflected their years of experience working with clients. They said, the greatest challenges are in dealing with people. We see the best in people, the worst, and everything in between. Different clients need different levels and types of support from their legal team. Sometimes it takes several interactions with a client and some wrong turns to figure out their needs and expectations. 12-7A. Clients in distress. A number of points can be made about many clients, particularly new ones. They are not sure what they want. They change their minds about what they want. They are not aware of all legal and non-legal options. The legal problem they tell you about involves other legal problems that they are not aware of, and that even you may not be aware of at the outset. The legal problem they tell you about involves other legal problems that they are not aware of, and that even you may not be aware of at the outset. Suppose a client, Tom Kelly, walks into the office and says, I want to declare bankruptcy. The following observations might be possible about Kelly. He has an incorrect understanding of what a bankruptcy is. He says he wants to declare bankruptcy because he thinks this is the only remedy available to solve this problem. He says he wants to declare bankruptcy because he thinks this is the only remedy available to solve his problem. If he knew that other options exist, like, for example, credit counseling and free mentoring advice from the Small Business Administration, he would consider them. What really troubles Kelly is that he is under pressure from organized crime in the neighborhood. Bankruptcy is the only way he thinks he can escape the pressure. If any of these observations is correct, think of how damaging it would be for someone in the office to take out these standard bankruptcy forms and start filling them out immediately after the client says, "I want to declare bankruptcy." Kelly needs a consultation with an attorney in order to find out 1. What bankruptcy entails, and 2. What alternatives to bankruptcy should be considered. One technique used by an experienced paralegal is to ask clients what they think would happen if the office were able to accomplish XYZ for them. When they answer, the paralegal then asks, "Is that what you want to happen?" The question can sometimes help the client put the matter in perspective. Maybe they don't really want a divorce, but they don't know of other options. Maybe they don't really need a will. Perhaps other forms of estate planning will meet their need. This is not to say that a law office must psychoanalyze every client or that it should distrust everything clients say when they first seek legal help. Rather, it is a recognition of the fact that most people are confused about the law and make requests based on misinformation about what courses of action are available to solve problems. Common sense tells us to avoid taking all statements at face value. Common sense tells us to avoid taking all statements at face value. People under emotional distress need to be treated with sensitivity. We should not expect them to articulate their intentions with clarity all the time in view of the emotions involved and the sometimes complicated nature of the law. (12-8) Assessing your own bias. You need to be aware of how your personal feelings might affect your work on a case. Such feelings are the foundation of bias, which is an inclination, tendency, or predisposition to think or to act in a certain way. How would you answer the following question? Am I objective enough that I can assist a person even though I have a personal distaste for what the person wants to do or what the person has done? Many of us would quickly answer yes to this question. We all like to feel that we are level-headed and not susceptible to letting our prejudices interfere with the job we are asked to accomplish. Most of us, however, have difficulty ignoring our personal likes and dislikes. Examine the following fact situations. In each situation, to what extent might an individual be hampered in delivering legal services because of personal reactions toward the client? Identify potential bias. 1. Mr. Kenrick, the client of your office, is being sued by his estranged wife for custody of their 2 small children. Mr. and Mrs. Kenrick live separately, but Mr. Kenrick has had custody of the children during most of their lives. Miss Kenrick has charged that Mr. Kenrick often yells at the children, leaves them with neighbors and daycare centers for most of the day, and is an alcoholic. Your investigation reveals that Miss Kenrick will probably be able to prove all these allegations and more in court. 2. Miss Banks is being sued by Mr. Banks for divorce on the ground of adultery. Miss Banks is the client of your office. Thus far, your investigation has revealed that there is considerable doubt over whether Miss Banks did in fact commit adultery. During a recent conversation with Miss Banks, however, she tells you that she has worked as a prostitute. 3. Paul and Victor are a gay couple who want to adopt Sammy, a 6-month-old baby whose parents recently died in an automobile accident. Sammy's maternal grandmother is not able to adopt him because of her age and health. She opposes the adoption by Paul and Victor because of their lifestyle. Paul and Victor are clients of your office in their petition for adoption. You agree with the grandmother's position, but have been assigned to work on the case. 4. Tyson Donaldson is a client of your office. His former business associate is suing Tyson for breach of contract. Your job is to help Tyson collect a large volume of records concerning the business. You are the only person in the office who is available to do this record gathering. It is clear, however, that Tyson does not like you. On a number of occasions, he has indirectly questioned your ability. Keep in mind that in each of these situations, the person paying the bills is the person against whom you may have a bias. In the vast majority of law offices, the last thing an attorney wants to do is antagonize a paying client. When confronted with unpleasant feelings, we rarely can wish them away or successfully pretend that they do not exist. Furthermore, the following admonitions are rarely helpful. Be objective. Be dispassionate. Don't get personally involved. Control your feelings. Such admonitions are too general, and when viewed in the abstract, they may appear not to be needed because we want to believe that at work we are objective, detached, and in control. We must recognize, however, that there are facts and circumstances that arouse our emotions and tempt us to impose our own value judgments. Perhaps if we know where we are vulnerable, we will be in a better position to prevent our reactions from interfering with our work. It is not desirable for you to be totally dispassionate and removed. It is clearly not improper for a paralegal to express sympathy, surprise, and perhaps even shock at what unfolds from the client's life story. If these feelings are genuine and if they would be normal reactions to the situation at any given moment, they can be expressed. The problem is knowing where to draw the line between expressing these feelings and reacting so judgmentally that you interfere with your ability. The problem is knowing where to draw the line, expressing these feelings, and reacting so judgmentally that you interfere with your ability to communicate with the client now and in the future. The starting point is to recognize how easy it is to go over the line. If your gut tells you that your personal feelings about the case are so intense that you may not be able to do a quality job for your client, you need to take action. Talk with your supervisor. You may have some misunderstandings about the case that your supervisor can clear up. You may be able to limit your role in the case or be reassigned to other cases. Without breaching client confidentiality, refer to Chapter 6. Contact your local paralegal association to try to talk with other paralegals who have handled similar situations. They may be able to give you some guidance. As mentioned earlier, attorneys often take unpopular cases involving clients who have said or done things that run the gamut from being politically incorrect to being socially reprehensible. As professionals, attorneys are committed to the principle that everyone is entitled to representation. Paralegals should have this same commitment, but attorneys and paralegals are human beings. No one can treat every case identically. In the final analysis, you need to ask yourself whether your bias is so strong that it might interfere with your ability to give the needs of the client 100% of your energy and skill. If so, you have an obligation not to work on the case. Ethical concerns also dictate this result. As we saw in Chapter 6, attorneys have an ethical obligation to avoid a conflict of interest. Such a conflict exists when an attorney has divided loyalties. An obvious example is an attorney who represents opposing parties in a particular dispute. An obvious example is an attorney who represents opposing parties in a legal dispute. A less obvious example is an attorney whose personal feelings could interfere with their obligations to give a client vigorous representation. The attorney's personal feelings should not be in conflict with a client's legitimate need for undiluted advocacy. Is the attorney going to be loyal to their personal feelings and values or to the client's cause. Clients should not be subjected to such conflicts of loyalties. When a conflict of this kind exists, the attorney has an ethical obligation not to take the case. The same obligation applies to paralegals. There should be no interference with a client's right to receive total commitment from everyone in the law office. (12-9) Communication Skills Analysis of an Interview. 12-9A Introduction. We will now examine portions of a hypothetical interview involving Sam Donnelly, who walks into the law office of Day and Day seeking legal assistance. Last month, Donnelly was a passenger in a car that collided with a truck. Our goal in this analysis is to identify guidelines that can help you conduct competent interviews. In particular, we want to increase your sensitivity to the large variety of factors that affect the quality of communication between client and interviewer. Assume that Mr. Donnelly is in the office of William Fenton, Esquire, one of the partners of Day and Day. During their meeting, the law firm agrees to represent Mr. Donnelly. The arrangement is confirmed in the attorney-client fee contract that Mr. Donnelly signs. See Exhibit 12 for a sample contract. At the conclusion of the meeting, Mr. Fenton calls his paralegal, Jane Collins. He asks her to come to his office so that he can introduce her to Mr. Donnelly. Attorney: the paralegal walks into Mr. Fenton's office. Mr. Donnelly: I want to introduce you to Jane Collins, who will be working with me throughout the case. I have asked her to schedule an appointment with you to do a comprehensive interview that will cover the facts you and I began to discuss today. Jane will be an additional contact for you throughout the case. If at any time you can reach me because I am in a meeting or in court, let Jane know what concerns, questions, or needs you have. I will be reviewing all of Jane's work and will be meeting with her regularly. Jane is a trained paralegal. She is not an attorney and therefore can't give legal advice, but she can do many things to help me represent you. Client: nice to meet you. Paralegal: Jane walks over to where Mr. Donnelly is sitting and with a smile extends her hand to offer a firm handshake. I'm very pleased to meet you. Mr. Donnelly: I look forward to working with you on the case. Let me give you one of my cards so that you'll know how to reach me. Client: thank you. Attorney: I've already explained to Mr. Donnelly that you will be doing an in-depth interview with him on the case. He can't stay today for the interview, so it will have to be scheduled. Paralegal: yes, before you leave today, Mr. Donnelly, let's discuss when it would be convenient for you to have the interview. Or if you need to check your calendar, I can call you. It is important to note that the supervising attorney, Mr. Fenton, has taken the initiative to introduce the client to the paralegal. This sets the tone for the client-paralegal relationship. Many clients have little more than a general understanding of what a paralegal is. Here, the introduction by the supervising attorney may be very specific in identifying Jane as a non-attorney who cannot give legal advice but has been trained to help attorneys represent clients. The paralegal will also act as a liaison between the attorney and the client. Note also the manner in which the paralegal treats the client. Jane walks toward the client to greet them with a firm handshake and a smile, telling the client that they look forward to working with them. Jane gives the client a business card. This is often appreciated because the client is probably meeting several new faces during the first few visits to the law office. Jane is very deferential to the client on when it would be convenient to schedule an interview with them. There are signs of a paralegal who is willing to go out of their way to make the client feel important and at ease. Analyze this. In the facts in the text, assume our paralegal, Jane Collins, extends hand to shake the client's hand, and the client refuses to shake Jane's hand. What should Jane do? What if the client says it is for religious purposes? What should Jane do? 12-9B, preparing for the interview. How do you get ready for an interview? The following lists some of the major steps you should take to prepare. The list assumes that this is one of the first legal interviews you have conducted. The list assumes that this is one of the first legal interviews you have conducted. A list in preparing for an interview. Schedule the interview during a time when you will not be rushed or constantly interrupted. Schedule the interview at a location that will be private and convenient for the client. Find out from your supervisor if the client has any special needs, such as wheelchair accessibility, as noted in our facts at the beginning of the chapter. Call, email, or write the client in advance to confirm the date and place of the interview. Give an estimate of how long the interview will take. If the directions are complex, offer to send a map, hand-drawn if necessary. Note, some older clients may not be tech-savvy and need things to be done in a more conventional way. Be mindful of who you are dealing with and accommodate their needs accordingly. Remind the client of anything you want them to bring to the interview, like, for example, insurance policies or copies of tax returns. Anticipate and prepare for the client's comfort, like, for example, a comfortable chair, a pad and pencil in case the client wants to take notes, and a supply of tissues. Know where you can quickly obtain fresh water or coffee after offering them to the client early in the interview. Before the interview, read everything in the office file on the client. Bring or copy any documents in the file that you may want to question the client about or have the client review during the interview. Have a final brief meeting or phone conversation with your supervisor to make sure you understand the goals of the interview. Find out if the office has any checklists you should use in asking questions. If none exist, prepare an outline of about a dozen major questions you will ask the client. You will have many more questions in the interview, but you can use this outline as a guide. If possible, spend some time spend some time in online doing general background research in the area of the law involved in the client's case to obtain an interview of some of the major terminology and legal issues. This overview may suggest additional questions you will want to ask during the interview. Use secondary sources as discussed in Chapter 9, such as a state-specific legal encyclopedia. Prepare any forms you will ask the client to sign during the interview, like, for example, consent to release medical information or authorization to obtain employment history records. Depending on your method of note-taking, electronic or conventional, have everything ready. Are your devices charged? Do you have your own supplies ready for note-taking, such as colored Sharpies or Post-it notes? Have extra supplies readily available, such as notepads or writing instruments, in case the client wants to take notes. Walk into the interview with the attitude that the client will be telling you a story that you have never heard before. Do not assume you know what the client is going to say, even if you have handled many cases of this kind. Be present. Either silence or turn off your smartphone. Have calls held unless it's an emergency. Give the client 100% of your attention and focus. In addition to the suggestions above, try to observe someone interviewing a client. Find out if anyone else in the office will be conducting an interview soon. If so, ask permission to sit in. Watching others interview can be very instructive. Another way to prepare is to read some intake memos or other reports written after interviews in other cases. They can be found in the open or closed files of office clients. Pay particular attention to the amount and kind of information obtained in these cases. Quick tip: before the interview starts, try and find some general areas of interest to project a relaxed and confident atmosphere. Talking about an event, such as a sports game, may put the client at ease. Make some small talk to ease any discomfort that the client may feel before you begin the interview. Your mental attitude in preparing for the interview is very important. You need to approach each interview as if it is going to be a totally new experience for you. It is dangerous to think that you know what the client is going to say, no matter how many times you have worked on a particular kind of case in the past. The danger is that you will not be listening carefully to what the client is saying. An interviewer who has an "I've heard it all before" attitude may block out what is unique about the facts of this client's case. The hallmark of the professional is to view every client, every problem, and every incident as different and potentially unique. There's never been one like this before. A professional interviewer, therefore, keeps probing for more facts to try to show that this case is not like all the rest. The goal of the professional is to find out what makes this case stand out, regardless of the fact that the interviewer may have experienced the set of facts being presented 100 times before. Projecting an air of attentiveness is important. No matter how many times you may have seen the fact scenario, for the client, it may be the first time they have dealt with a legal professional, and for them, it is all new and unique. Treat all your encounters that way so that you will get the most accurate and complete information from the client. When conducting legal interviews, however, or engaging in any task in the representation of a client, our goal is to try, within reason, to let our professional selves dominate. 12-9C. Environment. You need to consider the impact of the physical setting or environment in which you conduct the interview. It will usually take place in the office of the interviewer. If this office is not private enough, however, try to reserve the conference room or borrow an available office from someone else if it would be more private than your own. In our example, let us assume that Jane Collins' office is suitable for her interview with Sam Donnelly. There is a knock at Jane Collins' door. She gets up from her chair, goes over to the door, opens it, and says, as she extends her hand, Paralegal. Hello, Mr. Donnelly. I'm Jane Collins, Mr. Fenton's paralegal. It's good to see you again. Won't you come in? Did you have any trouble finding the office? Client. No, I had to use the bus, but it worked out fine. Paralegal. Let me take your coat for you. Please have a seat. The paralegal points the client toward a chair on the opposite side of the desk from where she sits. They face each other. In Exhibit 12-8, note the seating arrangement the paralegal selects as illustrated in Diagram A. I is the interviewer and C is the client. A number of seating arrangements are possible. The chairs can be arranged so that the interviewer and the client sit on opposite sides of a desk, Diagram A. Diagonally across
a desk diagram B on the same side of a desk diagram C, or in another part of the room away from the desk together diagram D. Seating arrangements are usually made at the convenience of the owner of the office. Rarely, however, is enough thought given to how a particular arrangement may help or hurt the flow of communication. Sometimes the seating arrangement will create an austere and official atmosphere. Other settings may be close and warm. 12-8, Exhibit 12-8, Possible seating arrangements during interviews. Of the four seating arrangements diagrammed in Exhibit 12-8, which do you think would be most effective? Which would you feel most comfortable with? Which do you think the client would be most comfortable with? There is probably no seating arrangement that will be perfect for all situations. The interviewer must be flexible enough to experiment with different arrangements. For most legal interviews, you will be taking extensive notes as the clients answer your questions. If you are going to make any notes about the client that you may not want them to see, like for example, appears reluctant to answer, you will want to select a seating arrangement that does not allow the client to read what you are writing. To some extent, seating arrangements can be a reflection of your personality. How do you want to project yourself? As an authority figure? If so, you might be inclined toward the seating arrangement in diagram A. Do you, on the other hand, want the client to feel closer to you and not have to have the impression that you are hiding behind a desk? When clients look up, do you want them to be looking straight at you? Diagram A. Or do you think that it might be more comfortable for them to be able to face in other directions? Diagram B, without appearing to scatter their attention. Of course, an office is much more than an arrangement of desks and chairs. Be careful about explicit messages around the room. Your political views may clash with those of the client. Do not broadcast your politics by having partisan literature on the walls or desk. Having a no smoking sign that says, "Don't even think of smoking here," is too abrupt. Courtesy will suggest a more friendly way of letting clients know that they should not smoke in your room. Like, for example, "Thank you for not smoking." You want the office to project a professional image of you. Your desk should not be cluttered with papers, books, and half-eaten food. Slogans and a messy desk usually suggest the opposite. Quick tip. Think about where you want to have an interview and who the client is. Sometimes having another person in the room is warranted. Keeping the door ajar may be helpful. If you feel uncomfortable, it may be appropriate to stop the interview and seek assistance. Simply excuse yourself for the moment. Technology update. The virtual client interview. One thing the COVID-19 pandemic taught us is that we can do most things virtually. Interviewing a client is no different. Virtual interviewing can be accomplished through mediums such as Zoom, Teams, Google Meet, and many other virtual meeting platforms. However, with these kinds of platforms, it is more difficult to establish a close rapport that in-person interviewing establishes. So, what are some of the techniques that can be used to establish a rapport and gain a client's trust and confidence in you and your firm or business? If a virtual interview setting is chosen, think about what issues you may encounter. For many, they have never used a virtual platform. You need to learn whether the client has internet access, a suitable electronic device, and skill to use a virtual meeting platform. For example, Let's say that the client is an older adult and cannot come to the office for the interview. Find out their access capabilities and whether there are friends or family that can assist. Let the clients know you will be sending an invitation to the meeting electronically with a link for the meeting at the agreed time and date. When starting a virtual interview, be sure everyone is comfortable and check all your connections. Make sure everyone knows how to use the video and mute components of the medium you have chosen. Introduce yourself as though it were an in-person interview with some introductory small talk to ease any nervousness of the client. Proceed as though you were conducting an in-person interview by telling the client who you are and what your purpose will be in the interview. Let the client know you'll be taking notes of the responses, which will assist in preparation of their case. Also, remind the client that the information shared is confidential, just as though it were being shared in person. Begin with your prepared questions to the client, always leaving room to explore areas when necessary. Try to not interrupt the client when responding to questions, as that will give the impression that you are rushing the interview. If the client has documents, discuss those and identify those documents. Depending on the circumstances, arrange for copies of the documents to be transmitted to your office, either electronically, hand delivery, or by mail. Let the client communicate the mode that they are most comfortable using. Virtual meetings take some getting used to, but they present a viable alternative when in-person meetings are not possible. Remember that just because you are virtual does not mean that etiquette and standard business practices do not apply. Dress appropriately. That means wearing professional business attire. During COVID-19, many professionals got creative and thought that they only had to wear business attire from the waist up. We all know what often happened. Don't eat during the interview. Don't eat during the meeting. We all know how that looks and feels. Having a cup of coffee or water available is fine, but don't eat your lunch in front of a client while conducting an interview. It gives the wrong impression and is simply not polite. Be sure your office area is clean and free from clutter. Some use background screens, but be sure that they are not distracting. As with in-person interviews, keep interruptions to emergencies only. No one likes to be disturbed when meeting with a client. This includes phones and other noises such as intercom announcements. When taking notes, find a method that is inconspicuous. Typing on a keyboard can be noisy and distracting. Regardless of in-person or virtual, do not interrupt or speak over people. It may show you are not listening to the client's responses and could agitate a client. Listen and try and wait to speak after the client concludes a response to a question. And finally, conclude by asking the client if they have questions. Discuss the next steps in the process and again proceed as though in person. Some virtual platforms are timed out and automatically conclude, oftentimes in the middle of a sentence. Know your systems and choose a platform where you control the time and when you leave the meeting. If you go over the appointed time, make sure your system permits you to continue without it closing off the meeting. That is embarrassing and impolite, to say the least. For those clients who are unfamiliar with the virtual meeting platforms, guide them through the process in the interview. When you are done the meeting, let the client know you are closing the meeting so they do not feel inextricably cut off. Explain the process and the virtual meeting will be as seamless as in-person experience. Explain the process, and the virtual meeting will be as seamless as an in-person experience. 12-9D, getting started.
Note that the paralegal Jane Collins went to the door to greet the client. Suppose that instead she had remained in her chair and called, "Come in a loud voice. Do you think it makes any difference whether the interviewer walks over to the client? Do you think it makes any difference whether the interviewer walks over to the client? When you walk into a room with someone, you are communicating the message, 'Come share my room with me.' If, however, you are seated at your desk and call the visitor in, the message to the visitor is likely to be, 'This is my room. I control it. You have my permission to enter.' Although this is not necessarily an inappropriate message, it is not as friendly and warm as going to the door to escort the client in. Note also, however, that the paralegal apparently did not go out to the front entrance of the law firm to greet the client. Here is what may have happened. The client came to the front door, was greeted by a receptionist, was told to wait in the reception area, and was then given directions to find the paralegal's office on his own. If this is what happened, it was a mistake. The paralegal should have left instructions with the receptionist to call her when the client arrived, and the paralegal then should have gone out to the reception area to greet the client and personally walk him back to her office. This would be the most courteous approach. Furthermore, you do not want clients roaming around offices, even if they know the way. A wandering client may overhear confidential conversations between other members of the firm or see open files of other clients on desks. This danger is minimized if the paralegal escorts the client from the front door to her office. Upon greeting the client, the paralegal reintroduces herself to the client. "Hello, Mr. Donnelly. I'm Jane Collins, Mr. Fenton's paralegal. It's good to see you again." She does not expect the client to remember her name. It is a sign of courtesy to reintroduce yourself at the beginning of a second meeting. Finally, never call a client by their first name unless expressly invited to do so by the client. Furthermore, do not interpret a client's calling you by your first name as an invitation for you to do the same with the client's name. Paralegal: "Thank you for coming in today, Mr. Donnelly. Are you ready for today's session?" Client: "Ready as I can be." Paralegal: "Good. How have you been?" "Not bad considering all this mess. I can't believe all this is happening." Being involved in an accident can be very upsetting. It must be very hard for you. Our office has handled cases like this before. While no one can predict how a case will turn out, you can rest assured that we will be doing everything possible to lessen the burden on you and to resolve the matter. Thank you. Let me ask you, Mr. Donnelly, is there anything that you want to cover now before we begin? This letter came in the mail this morning. It looks like the truck company has its lawyers on the case. Paralegal: The paralegal takes the letter from Mr. Donnelly and spends a few moments reading it. This is a letter from the attorney representing the truck company seeking information from you. They obviously don't know yet that we represent you. Once they know you are represented, it is improper for them to contact you directly. They need to go through your attorney. I'll let Mr. Fenton know about this letter right away. I'll scan it before you leave so that you can keep the original for your records. After Mr. Fenton sees this, we'll let you know if there is anything you need to do about the letter. For now, let us take care of it. Early on, the paralegal thanked the client. Thank you for coming in today. Throughout the case, the office may ask the client to do many things such as come to meetings, sign documents, and collect information. Each time, you should express appreciation for doing what was asked. Never expect the client to thank you. Although this may occur, you don't want the client to have the impression that you are doing the client a favor. The reverse is always true. Hence, constantly be appreciative. Soon after inviting the client in, the paralegal asked, "Did you have any trouble finding the office?" And a little later, "How have you been?" It is a good idea to begin the interview at a personal level with some small talk about the weather, how the client is doing, or a recent sports event the client might know something about. Within reason, of course, since clients are being charged by the hour, unless they have a contingency case with the office. Small talk helps put the client at ease. The client may still be a bit nervous about the accident or whatever led to the conflict and the involvement of the attorneys. Being a little lighthearted and personal for a few moments at the beginning of the interview may help break the ice. When clients are particularly stressed or overwhelmed, you need to provide reassurance that the office will be actively working on the case and that the situation is manageable. The paralegal did that here when she told the client the office has handled similar cases in the past and would be doing everything possible to lessen the burden on him and to resolve the matter. Comments such as these should help reassure the client. Of course, many clients want to be told they are going to win their cases. Avoid making any statement that could be interpreted as a promise or guarantee of success. Otherwise, the office could be sued for breach of contract if the case is not successful. Instead of telling a client, "You've got a great case," say something like the following: "There is no way of telling how a case will turn out. You've got a lot of good points in your favor, and we're going to work as hard as we can for you." The paralegal also told the client, being involved in an accident can be very upsetting. It must be very hard for you. Here, the paralegal is expressing understanding and empathy for the client's predicament. This is important. The comment tells the client that the paralegal is listening to what the client is saying. Mr. Donnelly refers to the mess and says, "I can't believe all this is happening." Rather than ignoring this comment, the paralegal lets the client know that she has heard what he said. This is comforting. On the other hand, you don't want to be patronizing or condescending. A comment such as, "You poor fellow," would obviously fall into this category. Interviewers often learn a large number of highly personal facts about the client's life. Think of how you would feel if you were revealing such facts about yourself to a stranger. Think of how you would want this person to react to what you are revealing. At such a vulnerable time, clients need understanding and compassion. This does not mean that you should lose your objectivity. As indicated earlier, if it would be natural for you to express an emotion in response to what a client tells you, express the emotion. For example, "I'm very sorry to hear that," or "I can understand why you'd be angry." At the same time, you need to have an appropriate professional distance from the emotions and drama of the client's story. Some clients will be understandably reluctant to talk about certain topics. Indeed, as an interviewer, you may feel uncomfortable delving into them. Examples might be prior bankruptcies a client has gone through, violence engaged in by the client in the past, or the client's marital history with a spouse. If, however, these topics are relevant to the legal services sought by the client, they must be covered. The client will be looking for signs that you are not embarrassed by such topics, that you can talk about them with appropriate sensitivity. The client will be looking for signs that you are not embarrassed by such topics and that you can talk about them with appropriate sensitivity. Of course, never be judgmental of the client. Do not ask the client, "Why did you do that?" if your tone is one of suspicion or disbelief. Clients should not feel that they are required to justify their actions or inactions to you. This obviously would not encourage open communication between interviewer and client. Also important was the paralegal's question. Is there anything that you want to cover now before we begin? Early in the interview, find out if the client has any immediate concerns or questions on his mind. This should be done not only as a matter of courtesy, but also as a technique to make sure the client has your undivided attention. On the way into the law office, the client may have been thinking of several things he wants to ask about. He may be worried that he will forget them. Or he may be a little embarrassed about asking his questions. Give the client a chance to express anything on his mind at the outset before you begin your barrage of questions. In our example, this technique worked. Mr. Donnelly did have something on his mind: the letter he received from opposing counsel. Paralegal. Our goal today is to obtain a comprehensive statement of the facts of the accident. It will take at least an hour, maybe a little more. As Mr. Fenton told you, I am a paralegal, not an attorney. I'll be able to help you on the case in many ways, but I won't be able to give you legal advice. That will have to come from Mr. Fenton. If anything comes up today that calls for legal advice, I'll bring it to Mr. Fenton's attention so that we can get you the response you need. Since I work for an attorney, you should know that everything you tell me is protected by the attorney-client privilege. Client. Fine. Paralegal. Before we begin, Mr. Donnelly, you mentioned that you had to take the bus in. Is there a problem with your car? Was it involved in an accident with the truck? Client. No. I let my brother borrow my car today. Paralegal. All right. I want to start by getting an overview of what happened on the day of the accident. Then we'll go back and fill in the details. I'll be taking detailed notes to make sure that I remember everything you say. Okay, what happened that day? This is the second meeting between the paralegal and Mr. Donnelly. Although the supervising attorney, Mr. Fenton, told Mr. Donnelly that James Collins was not an attorney, it is a good idea for the paralegal to reinforce this point. Paralegals who have contact with clients are sometimes pressured to give legal advice, making it clear at the outset that this is inappropriate. Can cut down on this pressure, although unfortunately it will not eliminate it. Making it clear at the outset that this is inappropriate can cut down on this pressure, although unfortunately it will not eliminate it. The paralegal also told the client that whatever he tells her is protected by the attorney-client privilege. The client needs to know this, but not in this way. The phrase attorney-client privilege is legal jargon. It is specialized or technical language that may not be understood by the general public. Avoid jargon unless the client needs to know it, and you explain it in a way the client can understand. When you use jargon or confusing terms, do not interpret the client's lack of questions to mean that the client understands the jargon. Do not wait for the client to ask you to explain unfamiliar terms. Take the initiative to provide explanations. In our example, it probably would have been sufficient to tell Mr. Donnelly that what he tells her will be confidential, rather than using the more technical phrase, attorney-client privilege. Another useful technique for the beginning of an interview is to briefly state the major goal of the interview. Here, to obtain a comprehensive statement of the facts of the accident, give the client an overview of what you hope to accomplish and how long it may take. Do this even if you have the client. Do this even if you gave the client this information when you set up the appointment. Let the client know you will be taking notes in order to have an accurate record of what he says during the interview. As indicated earlier, the document that contains the detailed reports of the interviewer is sometimes called the intake memo. See Exhibit 12-3. This will be prepared after the interview based on the interviewer's notes. Some interviewers recommend against taking detailed notes, particularly at the beginning of the interview when you want to maintain eye contact and establish rapport. If you follow this advice, at least some notes should be taken at the outset as reminders of the topics you need to come back to later for detailed. If you follow this advice, at least some notes should be taken at the outset as reminders of the topics you need to come back to later for detained questioning and note-taking. Occasionally, your supervisor will want you to tape record the interview. Be sure the client consents to the recording. At the beginning of the interview, say, This is Jane Collins, a paralegal in the law office of Day and Day. Today's date is March 12, 2024. I am in your law office with Mr. Samuel Donnelly. Mr. Donnelly, have you agreed to have this interview tape recorded? The latter question will help disprove any allegations that you secretly recorded the interview. On the tape, also state the names of the other people, if any, who are in the room during the taping. A good interviewer is always listening for clues to other legal or relevant non-legal problems. There is always a danger that an interviewer will block out anything that does not fit within the topics scheduled for discussion. In our example, the paralegal said to Mr. Donnelly, You mentioned that you had to take the bus in. Is there any problem with your car? Although the car apparently has nothing to do with the case, it was worth inquiring into. Suppose, for example, the client is not driving because of injury to his eyes caused by an eye doctor. Or perhaps the client had a contract dispute with an auto mechanic. It is a good idea to listen for suggestions or clues to other problems provided by a client. If you do not want to cover the matter immediately, make a note to raise it later in the interview at a more appropriate or convenient time. The major techniques and guidelines for beginning an interview are summarized as follows. Beginning the interview. Introduce yourself by name and title. If this is your second meeting with the client, reintroduce yourself. Do not call a client by their first name unless invited to do so by the client. Do not ask the client for permission to use their first name. Wait to be asked to do so. Express appreciation each time the client does something the office asks, like, for example, come in for an interview or reads and signs a document. Express appreciation each time the client does something the office asks, like, for example, comes in for an interview or reads and signs a document. Make sure the client understands that you are not an attorney and cannot give legal advice. Start at a personal level, like, for example, with some small talk, rather than launching right into the main task at hand. Review the goals of the interview with the client based on the assignment from your supervisor, and provide an estimate of how long the interview will take. Make the client feel that their case is special. Avoid giving the impression that you are engaged in anything boring or routine. Never tell a client how busy you are. It suggests to the client that they are bothering you and might give the impression that the office is disorganized. Express understanding and empathy for the client's predicament. Express understanding and empathy for the client's predicament without being condescending. Never be judgmental. Make sure the client understands that what is told to you is confidential. Find out if there are immediate concerns that the client wants to raise. Avoid legal jargon unless the client needs to become familiar with the jargon and you provide clear definitions and explanations. Let the client know you will be taking notes and why. Listen for clues to other legal and relevant non-legal problems that the office may need to explore. Begin new topics with open-ended questions. See Exhibit 12-9 on the kinds of questions an interviewer might ask. Spend the first few minutes obtaining an overview and outline of the entire event or transaction. Then go back to obtain the details. Encourage the client to give you the facts chronologically as a story with a beginning, middle, and end. If more than one event is involved in the case, cover them separately in the same chronological way. Then go into how the events are interconnected. If the client appears overwhelmed or unusually distressed, try to provide reassurance by letting them know that the office is actively working on the case and is doing everything it can. Do not, however, promise results or say anything that a client could interpret as a promise or even as a prediction of what the outcome of the case will be. Quick tip: do not assume that you can record a meeting without telling the client or individuals at the meeting. Many states require the consent of the person before a meeting can be recorded. Know your state's rules. Online exercise. Determine whether your state requires consent when recording conversations. Are you a one-party or two-party consent state? 12-9E. Kinds of questions. One of the early questions a paralegal asked Mr. Donnelly was, "What happened that day?" This is known as an open-ended question. It is a broad, relatively unstructured question that rarely can be answered in one or two words. An open-ended question gives the client more control over the kind and amount of information to be provided in response. It also gives the interviewer an opportunity to size up the ability of the client to organize their thoughts in order to present a coherent response. Here are additional examples of open-ended questions. What brings you in today? What led to the crisis at the bank? One of the most frequent used categories of open-ended questions is the overview question, which asks for a summary of something, such as an important event. For example, what happened during your first year in college? Or James Collins' question, what happened that day? An open-ended request, like for example, tell me about the problem, invites the same kind of broad response, but it phrased but but is phrased as a request rather than as a question. Open-ended questions or requests invite the person questioned to give a long and potentially rambling answer. Hence, they should not be overused. These questions are often most effective when beginning a new topic in the interview. At the opposite extreme is the closed-ended question, which is a narrowly structured question that usually can be answered in 1 or 2 words. Examples: how old are you? What time did the accident occur? Did you receive the letter? Closed-ended questions give the interviewer more control over the interview because they let the client know precisely what information is sought. If the facts of a case are relatively complex, you should consider spending the first few minutes asking overview questions in order to obtain an outline of the entire event or transaction, and then going back to obtain the details using closed-ended questions as needed. Once you have the big picture, you'll be better able to see connections among the individual facts. The paralegal in our example took this approach, and she said, I want to start by getting an overview of what happened on the day of the accident. Then we'll go back and fill in the details. She followed this up with the open-ended overview question, what happened that day? Both the request for an overview and the detailed questioning should be designed to encourage the client to tell the events of the case chronologically. The case may have many confusing aspects. The client may be inclined to talk about 4 or 5 things simultaneously: the accident, the hospitalization, the events leading up to the accident, the deceitfulness of the other side, etc. The best way to conduct an orderly interview is to help the client structure the case as a story with a beginning, middle, and end. Hence, you should regularly ask chronological questions, such as what happened next, or what did you do then? If the client says something substantially out of chronological sequence, politely say, could we get to that in a moment? First, I want you to finish telling me what happened after. Although you want to see the interconnections among the various events of the case, the discussion may become tangled and confusing unless you cover one topic at a time in the same methodical manner. In most instances, the most methodical way is chronologically. In general, avoid asking leading questions in which an answer is suggested in the question. For example, you didn't return the call, did you? Did he tell you about the defect in the engine after you already said you would buy it? The danger of a leading question is that a nervous client or witness will simply give you the answer you appear to want. Leading questions might sometimes be useful when trying to challenge something that a hostile witness is saying, but this approach should obviously not be needed with the office's own client. If a client is having difficulty remembering something, like for example the weather on a particular day, a leading question might help jog the memory. Like for example, was it raining that day? If a client needs constant prodding through leading questions, however, you may have reason to doubt the client's entire story. Another category is the corroborative question, which seeks to verify or corroborate by seeking additional or supportive facts. For example, were there any passengers in the car who will back that up? Avoid combination questions. Those with more than one part, they can confuse the person being interviewed. There are 2 kinds of combination questions, multiple choice and add-on. A multiple choice question asks the client or witness to choose among options presented by the interviewer. It is an or question. For example, did you personally review the balance sheet, or did you rely exclusively on what the accountant told the committee? The interviewee may not remember both options and respond only to the last part of the question. An add-on question consists of several questions phrased as one. It is an and question. For example, when did you arrive in Dallas, and how long did you stay there? Two questions asked at once are sometimes referred to as double-barreled questions. Of course, add-on questions could have more than two parts. For example, was your salary when you began work at the company at the time of the accident and on the date you were terminated? For example, what was your salary when you began work at the company at the time of the accident and on the date you were terminated? Avoid add-on questions for the same reason. You should avoid most multiple choice questions. They can be confusing. There are some combination questions that are relatively simple. For example, was he driving a car or a truck? And what is your husband's name? And where was he born? Yet the danger of confusion still exists. And the better practice is to break all combination questions into individual questions that are asked separately. The final question that should always be asked at the end of the interview or at the end of a separate topic during the interview is the wrap-up question. It asks whether the interviewee thinks everything has been covered. Okay, before we conclude, have we gone over everything you wanted to say about? This gives clients the opportunity to raise or reinforce anything of particular importance to them. See Exhibit 12-9 for an overview of the major kinds of questions an interviewer can ask. Exhibit 12-9, Overview of Interview Questions. Open-ended questions. Open-ended question, a broad, relatively unstructured question that rarely can be answered in one or two words. The question encourages interviewees to express what is on their mind in as much detail as they choose. Example, tell me what happened on the day of the accident. What kind of a marriage did you have? Overview question. An overview question asks for a summary of an event or condition. Example, what are the major incidents that led to the dismissal? Could you start off by giving a brief description of what happened at the party before the shooting? Closed-ended question, a narrowly structured question that usually can be answered in one or two words, often yes or no. Example, are you seeking a divorce? Were you wearing your glasses when you saw the accident? Did your husband ever hit you? Chronological questions, a question designed to encourage the interviewee to describe what happened in the order in which events occurred, by date and time, step by step. Example, then what happened? What did he say after he saw the accident? What happened next? Leading questions, a question that suggests an answer within the question. Example, where was the fender dented? The car wasn't damaged when you received it, was it? You were traveling 75 miles per hour? Corroborative questions, a question designed to corroborate facts by seeking additional or supportive facts. Examples, who else saw the accident? Were you the only one who complained? Do you have receipts? combination questions. A question that has more than one part. Examples: did you accept the offer, reject it, or ask for more time to respond? Multiple choice. What school do your children attend? And are you satisfied with their progress? Add-on. Wrap-up question. A question asked at the end of the interview or at the end of a separate topic within the interview, in which the interviewee is asked if there is anything to add. Things has been left out or inadequately covered. Example: have we covered everything? And anything more on the phone calls you received? Is there anything else you want to add? Social media. Social media and the client interview. Do your homework. Sometimes you can thoroughly prepare for a client interview, and when you can, do it. Areas that provide a vast amount of information about clients, past, present, and future, are social media sites. You can get to know potential clients by checking their online presence. Most of us, when we meet someone new, almost immediately do an online search on them. This should be a practice prior to interviewing a client. For example, let's say the client is coming in about a recent firing from a company. They claim that they were the model employee and the employer discriminated against them because of their political beliefs. By doing a social media search, you can discover basic information about that person. Did they post on Facebook, Instagram, or WhatsApp? What information did they post? Did the potential client discuss their job or employer? Social media also will disclose friends, family, and associates. Posts may disclose information about the potential client's beliefs about certain coworkers. For example, the client may have posted a rant about a coworker or others on social media that may be enlightening about the client and the client's propensities. The information can be used as a check of the client's truthfulness and ability to be forthcoming with information during the representation. Reviewing social media for pictures and videos can also provide insight into a client's character and background. When reviewing the social media accounts, preserve what you see before the interview. When clients think they may have incriminating information, the client may attempt to delete information that may be relevant. Again, this goes to a client's truthfulness and veracity and can be an important component as to whether a case is accepted by the firm or not. Consequently, by doing your homework prior to an interview, you can verify the client's story against what you reviewed on social media. At the very least, your firm can make an informed decision about the client and the case and can anticipate what they are getting into if the case is accepted. It also should be a warning to the client that you and the firm are thorough and come prepared when representing clients. It is an important message to send. Think about the TikTok video showing an accident victim dancing or posting a picture on Instagram playing tennis post-accident. And the flip side is true, as social media may have pictures of the accident showing the weather conditions at the time or the condition of the car. The bottom line is that social media is an invaluable tool as you prepare for an interview of a new client, and as we will see in subsequent chapters, as an investigative and discovery tool in the litigation process. Use it to your advantage no matter what information you learn. 12-9F, attentive listening. Being involved in a legal dispute is often traumatic. In addition to wanting to be treated competently as a plaintiff or defendant, clients want a law office that is genuinely concerned about them as people. They often are desperate for a sympathetic ear. One of the best ways to demonstrate concern is through attentive listening. This requires taking affirmative steps to let clients know that you have heard what they just said and that you consider every client meeting to be important. Unfortunately, listening is not a skill that comes naturally to us. Too many times in today's society, what passes for listening is merely waiting quietly for your turn to talk. To help combat this problem, let's review some techniques of attentive listening. Techniques of attentive listening. Make it obvious to the client that they have your full attention. If a receptionist answers incoming calls to the office, let the client hear you tell the receptionist that you are in an interview and do not wish to be disturbed. If you know that there might be an interruption during the interview, alert the client and apologize in advance. Occasionally, lean forward toward the client as they speak. Avoid being fidgety or appearing nervous. Take notes. This is an obvious sign that you think what the client is saying is important. As indicated earlier, however, some interviewers avoid extensive note-taking at the beginning of an interview in order to establish rapport through concentrated attention. Maintain eye contact whenever you are not taking notes. As the client speaks, give frequent yes nods. Also say, okay, or I see when the client momentarily pauses while answering your question. Connecting or reinforcing words such as these let the clients know you are following what they are saying. Several times during the interview, use the client's name, like for example, Mr. Jones. Was that the first time you spoke to your accountant last year? And did I hear you say, Miss Phillips, that you leased the car rather than own it outright? Periodically, let the client know you are providing useful information. Make comments such as that you could be very important, or I'm glad you recall the event in such detail. In addition to listening to the words of the client, listen to the feelings the client is expressing through body language. Words are not the only way a client lets you know they are anxious, suspicious, worried, or in pain. Frowns, hand gestures, eye contact, and a lack of eye contact are examples of body language, nonverbal communication. At appropriate times, restate a feeling the client is trying to describe. Like, for example, the stress you were under must have been overwhelming. You may want to do this in the form of a question, like, for example, you were really angry when you found out, weren't you? Occasionally, read something from your notes out loud to the client and ask if you have correctly recorded what they have said. This reinforces the value of precision in the practice of law, as well as letting the client know the importance of this interview. Recap regularly. Often during the interview, paraphrase and summarize what the client has said and ask if your paraphrase or summary is correct. Let me see if I understood what you have said. Occasionally, or often if needed, ask the client to clarify or elaborate on something that has been said. Ask spontaneous questions that occur to you while listening to an answer of the client. This helps demonstrate that you are not trying to fit the client's answers into your preconceived notions about the case. Rather, you are following the client's train of thought. Refer back to what the client said earlier. Like, for example, when we were discussing the purchase, you said that your father wanted his brother to manage the property. Could you tell me what you meant? Never express impatience, no matter how frustrated you are at the client's failure to answer what you feel should be an easy question. Never express impatience, no matter how frustrated you are at the client's failure to answer what you feel should be an easy question. While a client is answering a question, try to avoid interrupting unless rambling occurs and you need clarification before the client moves to another point. Do not finish the sentences of clients, no matter how certain you are of what they are trying to say. Finishing someone's sentences demonstrates your impatience and is condescending. Some experienced paralegals handle the same kind of case over and over. Clients, however, want to feel that their case deserves and will receive individual attention. They do not want their cases handled in an assembly line or mass production manner. They appreciate having experienced attorneys and paralegals working for them, but they are particularly pleased when they feel that the office is treating their case as special. For more on the skill of listening, see the categories discussed in Chapter 3. Passive listening, appreciative listening, evaluative listening, judgmental listening, empathetic listening, Me Too listening, and active listening. 12-9G, comprehensiveness. A major goal of the most legal interviews is to achieve factual comprehensiveness. You want to obtain as many relevant facts as the client is able to give. The most important technique in accomplishing this goal is fact particularization, FP, discussed earlier in the chapter. Also important are corroborative questions that ask about documents or other individuals who can support the version of the facts the client is relating. Most clients want to give you facts that support their case, yet you need to encourage them to tell you negative as well as positive facts. Let them know how important it is for the attorney to know all the facts. One of the preoccupations of the other side is to find the facts that will hurt the client's case. The client's attorney must know all the facts in advance so that they can prepare a response when these facts come out, as they inevitably do. Earlier, we said that checklists of questions can be helpful in preparing for an interview. Be careful, however, when using checklists. Although they can provide guidance on what to cover in the interview, you must be flexible enough to deviate from the checklist when relevant topics come up that are not on the checklist. Use the checklist whether written by others or prepared on your own as no more than a starting point. Suppose, for example, you are interviewing a client about her financial assets. You are working from a checklist of questions on wages, real estate, holdings, stocks, bonds, etc. During the interview, the client happens to mention an ailing grandparent who is very fond of the client. This suggests the possibility of another possible asset, inheritance from this grandparent. Suppose, however, the checklist contains no questions about future inheritances. Common sense, one of the guides to formulating questions discussed earlier in the chapter, should tell you to ask whether the client thinks they might be a beneficiary in someone's will. Hence, if you have a checklist of questions, use it. But don't be so tied to the checklist that you fail to hear or respond to something the client says that does not fit into the checklist. Take accurate notes on the facts the client gives you, including the extent of the certainty or uncertainty a client expresses about a fact. Suppose the client tells you, "I'm not sure," how fast an approaching car was going, but then says it was about 50 miles per hour. Your final report based on your notes should say, when I asked the client how fast the car was going, the client said they were not sure. Then they estimated about 50 miles per hour. This lets the supervising attorney know that the client may be vulnerable as a witness in court if questioned about the matter of speed. An interviewer does not achieve the desired factual comprehensiveness unless they ask about the event and record the extent to which the client is certain or uncertain about the facts conveyed. The techniques for obtaining factual comprehensiveness are summarized in Chapter 12-10. Exhibit 12-10, Achieving Factual Comprehensiveness. Apply the technique of fact particularization to all the major facts the client tells you about the case. See Exhibits 12-4 and 12-5. Ask corroborative questions. See Exhibits 12-9. Encourage the client to tell you negative facts by explaining why you need to know them. Namely, to allow the attorney to prepare a response to them if they come up during negotiations or litigation. Probe beneath client opinions to obtain the underlying facts, particularly observed facts. Distinguish between facts the client has directly experienced through the senses, observed facts, and conclusions they have made about the facts, inferences. Follow available checklists of questions. Be prepared to ask questions not on the checklist if they are related to topics on your prepared agenda of questions. Ask questions to determine the extent to which the client is certain or uncertain about an important fact. See Exhibit 12-7. Where appropriate, use demonstrations and exhibits to elicit further information. For an example, see the timeline in Exhibit 12-6. After each separate topic is covered during the interview, and at the end of the entire interview, ask wrap-up questions to determine if the client thinks anything has been left out or has not been covered adequately. See Exhibit 12-9. 12-9H. Ethics and Interviewing. Paralegal. Telephone rings. Excuse me, Mr. Donnelly. Yes, hello, how are you? No, the Jackson case has been resolved. Mr. Jackson decided not to go through with the suit after McDonald made its offer. You're welcome. Sorry, Mr. Donnelly. Let's get back to a legal interview may be conducted competently and ethically. Unfortunately, there are more than a few opportunities for an interviewer to run afoul of ethical rules. Mr. Donnelly has just heard the paralegal discuss the Jackson case on the phone. This is a violation of the paralegal's ethical obligation to preserve client confidentiality. Even though Mr. Donnelly may have not understood anything about the Jackson and McDonald case, he was not entitled to hear what he heard. He should not even know that Jackson or McDonald is a client of Day and Day. Revealing information about a client is a breach of confidentiality. Whether it is done intentionally or carelessly. Mr. Donnelly may now have the impression that the paralegal will be as careless about discussing his case. Mr. Donnelly may now have the impression that the paralegal will be as careless about discussing his case. Mr. Donnelly may now have the impression that the paralegal will be as careless about discussing his case in front of strangers. Client, a friend of mine told me that if another car rams into you and commits a clear traffic violation, their negligence is automatic. Is that true? That's a good question. I'll take it up with Mr. Fenton and get back to you. All legal questions like that need to be dealt with by an attorney. Another major ethical danger that can arise during an interview is giving legal advice. As we saw in Chapter 4 and 6, legal advice is a statement or conclusion that applies the law or legal principles to the facts of a specific person's legal problem. The more contact a paralegal has with clients, the greater the likelihood the paralegal will be asked to give legal advice. This is especially true during legal interviews. Clients are often hungry for answers. Mr. Donnelly is no exception. The client asked the paralegal whether a traffic violation makes one negligence automatic. Even general questions about the law could be interpreted as questions that call for legal advice. Mr. Donnelly is probably trying to understand how the courts will handle his case. Suppose the paralegal knows the correct answer. Think of how tempting it would be to answer the question. It takes a lot of willpower to refrain from answering. The paralegal wants to appear intelligent. We all want to show off what we know. Be conservative, however, about ethics. See Chapter 6 for a summary of 25 major ethical guidelines a paralegal must follow. To be safe, avoid giving an answer. The paralegal told Mr. Donnelly they would get back to them after consulting with Mr. Fenton. This is better than coldly saying, "I'm not allowed to answer that question," when the paralegal said, all legal questions like that need to be dealt with by an attorney. They are also helping to train the client about the limitations inherent in the paralegal's role. This may cut down on future pressures from Mr. Donnelly to seek legal advice from them. Some of the main areas of ethical concern that a paralegal must consider when interviewing a client are summarized as follows. Avoiding ethical problems during interviews. Do not accept a case on behalf of the office and do not set fees. You can tell someone what kind of cases the office handles, but you cannot tell someone that the office will take the case. Only an attorney can establish an attorney-client relationship or set fees. Do not discuss fees with a client except to state the amount of an initial consultation fee, if any. If you cannot avoid phone interruptions or visits by others to your office during the interview, be sure that you do not discuss the facts of other clients' cases. Never mention the names of clients or their opponents in front of another client, even if you are certain that the latter will not recognize these names. Excuse yourself and leave the room if you must discuss anything about other cases. If you know you may be interrupted during an interview, let the client know in advance. While talking to the client, do not have open files of other clients on the desk. Do not let the client wander in the corridors of the office, like, for example, to go to the coffee station. You do not want the client to overhear conversations about other cases among attorneys, paralegals, secretaries, or other employees. Make sure the client understands you are not an attorney. Resist pressures from the client to give legal advice. When in doubt about whether a question you are asked calls for legal advice, do not answer. Refer the matter to your supervising attorney. Avoid saying anything that could be interpreted as a prediction of how the case will be resolved. If the client says anything during the interview that suggests the possibility of a client of interest, like for example, the client tells you that the opposing side's spouse was once represented by your law firm, stop the interview and check with your supervisor or another attorney about whether you should continue. What is clear in the practice of law is that ethics are important. We all have codes of conduct that we must follow. In RE CAISE 359 BR 152 ED KEN 2006 shows us the limitations that must be followed when paralegals interview clients on behalf of an attorney. The Kaises made a complaint against their bankruptcy attorney, where the result cost their former attorney. The Kaises made a complaint against their bankruptcy attorney, where the clients The Kaises made a complaint against their bankruptcy attorney, where the results cost their former attorneys. Order of the Court, a case study. In RE case, United States Bankruptcy Court for the Eastern District of Kentucky, 359 BR 152 ED KEN 2006. An RE case is a bankruptcy case where the paralegal interviewed the clients, prepared documents, and did just about everything. However, the case went RE when the clients ultimately filed a complaint against the attorney. Here, the debtors needed to file for bankruptcy and hired Ginger Knight. The Kaises met with Knight's paralegal in September 2004 when it was discussed that they would file Chapter 7 bankruptcy. All meetings had been with the paralegal. At some point, it was determined that the Kaises could not file a Chapter 7 bankruptcy, as based on their financial situation, needed to file a Chapter 13 bankruptcy. After months of working with the paralegal, the attorney finally had a conversation with the Kaises, advising them that the change in filing type needed to occur. During the Chapter 13 proceeding, the Kaises were unable to comply with the plan submitted, and ultimately the matter was dismissed. The bankruptcy trustee then attempted to refund any monies that the Kaises had paid under the Chapter 13 filings. However, the Kaises disputed the attorney's fees of $695 that Knight was entitled to. The hearing occurred before the bankruptcy courts. In this case, the paralegal was responsible for the initial client meeting, presentation of any necessary documents to retain Ms. Knight's, discussion of the type of bankruptcy that would be filed on their behalf, and the application of various exemptions available to them under law, and finally review and execution of the bankruptcy petition and related documents. ID at 155. The attorney became involved later in the case. The court reviewed the definition of paralegal and the meaning of supervision by an attorney. The court then focused on what constituted the unauthorized practice of law in Kentucky. It noted numerous tasks that an attorney should perform and not the paralegal.
They include 1. Determining when to file bankruptcy cases. 2. Deciding whether to file a Chapter 7 or a Chapter 13. 3. Advising debtors about exemptions or which exemptions apply to their property. 4. Using a bankruptcy questionnaire to prepare a petition. 5. Defining and explaining concepts of bankruptcy and other legal terms of art. ID at 156, citations omitted. What the court determined was that the Cuzzies only dealt with the paralegal and not the attorney in discussing the bankruptcy, since the attorney never meaningfully communicated with the clients. The court ordered that all fees and expenses related to the bankruptcy be refunded to the Cuzzies. Discussion questions. Examine NRE Cuzzy. What facts did the court find surprising in this case? How did the court define paralegal and the related responsibilities? What are the fundamental requirements in the attorney-paralegal relationship? What did the court suggest should have been done differently by the attorney in the Cuzzy case? (12-9I) Ending the interview. The interview is over when you have accomplished the objectives of the interview or when the client is not able to provide you with additional information. The client may need to check some of their records at home or contact a family member or business associate in order to answer some of your questions. The missing data can probably be communicated on the file or by email. Use wrap-up questions to give the client the opportunity to raise anything that perhaps they think should have been covered. For example, you could say, before we end today's session, let me ask you if there is anything you think we haven't covered or haven't covered enough. If the client raises anything, you may want to take some additional time now to go over the client's areas of concern, or you may have to tell the client that you'll get back to them on when you will be able to go over those concerns. The important point is to find out how the client feels about what was discussed during the interview and to respond to any of his concerns. Often the client needs to sign documents that authorize the office to obtain confidential information about the client, like, for example, a consent to release medical information. Be sure to explain the document clearly to the client and give them time to read through what is being asked to be signed. Do not brusquely hand the client a document and say, I'll need your signature on this form that will allow us to get your medical records. Here is a more appropriate approach. Paralegal, handing the document to him. Mr. Donnelly, I want you to take a look at this document. It's a consent to release medical information. We'll use it to ask doctors, hospitals, and other medical providers to give us information about your medical condition. Your signature tells them that you agreed to let them release the information to us. Would you please take a moment to read through it and let me know if you have any questions about it? If not, there's a space at the end of the document for your signature. Client, okay. Paralegal, once you sign it, I'll keep the original and get you a copy for your records. The client will want to know what is going to happen next after the interview. Remind the client of any scheduled appointments, like, for example, doctor visits or depositions. If there are none, tell the client that you will be preparing a report for the attorney on the interview and that the office will be getting back to the client. Also summarize anything you asked the client to do during the interview, like, for example, call or email you
to provide the exact address of a former employer. Begin preparing a draft of your intake memo soon after the interview is over, while the data and your notes are fresh in your mind. See Exhibit 12-3. Do this even if you need to obtain additional facts to include in your memorandum by follow-up interviewing or investigation. Refer to Chapter 11. Do not wait until you have all the facts before you start writing. Also, make a notation in the client's file that you conducted the interview. If the file does not have a summary sheet on which client events can be recorded, place a brief note in the file stating the date and place of the interview. Someone else in the office working on the case, like for example, supervising attorney, law clerk, or secretary, should be able to look at the file and know what has been done to date. For a summary of these and similar steps to take at the end of an interview, see Exhibit 12-11. Exhibit 12-11, ending the interview. Ask the client to sign any standard forms needed by the office, like for example, consent to release medical information or authorization to obtain employment history records. Before doing so, clearly explain what the document is designed to do and give the client the opportunity to ask any questions about the document before they sign it. Use wrap-up questions to ask the client if there is anything else on their mind that they would like to raise before the interview is concluded. Ask if the client thinks any of the topics covered need more discussion. Let the client know precisely what the next step will be in the office's representation of the client. Like for example, the attorney will call the client or the paralegal will schedule a medical examination of the client. Remind the client of how to reach you. Have additional copies of your business card on the desk. Thank the client for the interview. Start preparing a draft of your intake memo soon after the client leaves. In the client's file, make a brief note of the fact that you conducted the interview. Include the date and place of the interview. Quick tip: all clients are different. At the end of the interview, discuss with the client the preferred means of communication. Does the client prefer email, telephone, or written communications through mail? Different generations may prefer different modes of communication. Establish this at the end of the initial interview, which shows a sensitivity and detail that may be overlooked. Don't assume that all clients communicate in the same way. Ask. 12-9J, Personality Observation. After conducting an interview, you should formulate some preliminary observations about the client's personality, particularly as they pertain to their sincerity, credibility, and persuasiveness. Here is how one attorney described this aspect of the interview. Assess the client's personality and whether you think the office can work with this person. Watch for red flags or danger signals, including the client who is emotionally distraught or vengeful, is inconsistent with the story or avoids answering questions, has unrealistic objectives, suggests use of improper influence or other unethical or illegal conduct, rambles, wanders off the subject, or constantly interrupts you, tells the office how to run the case, has already discharged or filed disciplinary complaints against other lawyers, has a personality disorder, or is flirtatious. In your intake memo to your supervisor, include your observations and assessments relevant to concerns such as these. Sometimes you can detect personality traits that spell problems and may be a deciding factor in that individual becoming a client. Be honest and straightforward in your intake memo. These observations may be relevant in whether the firm takes the case. 12-10. Improving your interviewing skills. There are many ways to improve your interviewing skills. Be a perpetual student. Always be inquisitive. Never be totally comfortable with any of your skills. One of the fascinating aspects of working in a law office is the availability of infinite opportunities to grow and improve. Ways to improve your interviewing skills range from watching a video on YouTube to performing a search on Google, Bing, or Yahoo. Attend seminars that include the topic of legal interviewing. Like, for example, CLE, Continuing Legal Education, seminars for attorneys conducted by bar associations, or CLE, seminars conducted by paralegal associations. You can also ask someone you respect in the office to observe you interviewing a client and then give you a critique. You will need the advance permission of the client for this person to sit in. In addition to whatever feedback your supervisor gives you about the intake memo that you submit on the case, ask them for suggestions on how the memo and the interview could have been improved. You can also ask others you respect in the office to read your intake memo and critique it. An experienced interviewer will be able to see if there appears to be any gaps in what you covered in your memo. Another way to improve your interviewing skills is to sit in when others in the office are interviewing clients. Read their memos on the interview and ask them questions about their interviewing techniques. To observe someone else's interview, you will need the consent of the interviewer and of the client interviewee. And finally, ask attorneys and other paralegals about their interviewing experiences, even if you are not able to watch them conduct an interview. This is a helpful method to provide you with some basic understanding of the process. (12-11) The difficult client. Once someone is accepted as a client, the relationship between the office and the client is likely to be smooth and mutually beneficial. Occasionally, however, you will encounter clients who can be troublesome. Here are some examples. The client who knows all the law. Some clients are quick to tell the office that they know the law. They may have been in litigation before, have taken courses on the law, have a close relative who is an attorney, or have read a good deal about the law online. The difficulty arises if such clients are always second-guessing the way the office is handling their case, or are unduly critical of anyone trying to help them. Ultimately, the attorney in charge of the case must decide if the office can continue to work with such clients. All clients, of course, are entitled to their opinions about the legal system and about anyone trying to help them. Indeed, clients have the right to fire their attorneys at any time. The central question is whether a client is prepared to listen to the advice provided by the attorney. The client is not obligated to follow every recommendation, but there may be no point in continuing with the attorney-client relationship if the client does not trust the attorney's professional judgment. Paralegals working with such clients may be careful to avoid arguing with them or giving them legal advice. If a client starts lecturing a paralegal about the law, the best response is to listen respectfully
and then respond by saying, "I'll be sure to let the attorney know what you have said." As with all client contacts, make a brief note in the file on this exchange indicating the date of the contact, what the client wanted, and what you said or did in response. The angry client. Some clients can be very angry. They may feel outrage at the injustice someone has allegedly committed against them. It is important that such clients be given a chance to express themselves. At the very least, they need to know that the office they have hired understands what they have been through and how they feel. They need an opportunity to vent. If, however, they continue to be angry after they have had this opportunity, the office may have difficulty providing them with effective representation. As indicated earlier, it is important to show empathy for a client by making comments such as, "This must be a very difficult time for you," or "I can understand why that would be upsetting." These comments can have a settling effect on clients without engulfing the office in an emotional thicket. You do not want to lose your professionalism by adopting the same pessimistic or hostile frame of mind as the client. The demanding or suspicious client. Some clients have difficulty believing that everyone in the office is not preoccupied with their case. They demand instant attention and results. "Why is it taking so long? I want this thing over." They may interpret delays as a tactic by the office to run up fees. An obvious response is to explain that the courts and the legal system often work at a slow pace unless an extreme emergency exists. During the initial interview, the office needs to head off or offset any unrealistic client expectations about how much time the case will take by providing a time range to complete such cases. The client also needs to be told that complications, like for example, new counter demands by the opponent, almost always create additional delays. Generally, it is not helpful to point out that there are other clients who also need the attention of the attorneys and paralegals in the office. One possibly effective approach is to keep demanding clients constantly informed of the status of their case. One possibly effective approach is to keep demanding clients constantly informed of the status of their case. The office could send them copies of documents as these are prepared for them, and also send periodic reports on the status of their case. Quick tip: email and client portals are effective ways to keep in communication with clients and provide them with up-to-date information. If an order from the court is entered, share it with the client, or if a letter from opposing counsel is received, share that with the client, if appropriate. They will be informed and feel acknowledged. The client who lies. There's a difference between clients who give facts a favorable interpretation and clients who lie. Assume, for example, that an office represents a husband who is seeking sole custody of their children in a bitter divorce case. It is understandable that they will attempt to portray themselves as a loving parent. They may glowingly describe the positive effect they have had on their children by attending sports events with them and by helping them with their homework. Careful questioning and further investigation will help determine whether they have exaggerated their role. If they have an experienced legal team, will know how to present. If they have an experienced legal team, will know how to present their case in a favorable light without compromising the truth. Suppose, however, that the father goes beyond exaggeration. For example, they may falsely claim that they do not use corporal punishment on the children, or they may deny that they take illegal drugs in front of them in spite of evidence to the contrary. Of course, if negative facts can reasonably be interpreted in the father's favor, The office has an obligation to present this interpretation to the court. Yet, it may eventually become clear to the office that the client has a tendency to lie. Serious ethical problems can arise in such cases. As we saw in Chapter 6, an attorney has an ethical obligation to avoid telling the court something that is known to be false and to avoid actively helping a client lie to the court. Withdrawal from a case by an attorney is justified when continued representation of the client would cause the attorney to violate an ethical obligation. Furthermore, it may be impossible for the attorney to provide competent representation without knowing all available facts. The client must be told that the attorney cannot rebut negative facts without knowing what those facts are before someone else reveals them. The client cannot make those facts go away by lying about them or concealing them. If the office cannot convince the client of this reality, the likelihood of representing the client effectively and ethically is low. Let's take a final look at our facts from the beginning of the chapter. As we learned, Mr. Eliasson was not happy that the attorney was not present for the initial interview. He became angry and agitated. The facts throughout the chapter suggest that the paralegal may have calmed down the client as the interview began. However, the client reveals his propensities early on. If Mr. Eliasson continued being aggressive during the interview or simply left, the best practice is to just let him leave. Communicate with your attorney what happened, and the attorney will determine the appropriate follow-up with the potential client. This may be one of those situations where taking the case may not occur. Or perhaps the client was having a bad day and the attorney can't address the issues with a phone call. There are many possibilities open, but for you as a paralegal, be sure to communicate in writing exactly what happened at the client interview. Let the attorney determine the next steps. Real-world perspectives. On-the-job observations. Paralegals play an important role in interviewing and interacting with clients generally. As some of our paralegal perspectives suggest, developing trusting relationships with clients is important and often is seen not only in interacting with clients, but also in assisting in making the process easier and less stressful. Here's what a paralegal in the estate planning area had to say. What I like best about estate planning is that you work with people on a very individual basis. I don't think that in many other areas of law, you get that one-on-one contact with the client. You're working with people while they are thinking about the most important things in their lives, their families, their wealth, and how to distribute it, and what they want to happen after they pass on. A lot of the clients contact me directly with their questions for the attorneys. Some of the widows especially are more comfortable calling me with their questions. They seem to think their questions might be stupid, and they're embarrassed to ask the attorneys directly. I can take their questions and see that the attorneys respond to them promptly. Bassett, Top Gun Patricia Adams, Legal Assistant of the Year, 6 Legal Assistant, today 70. A very unique and different perspective is presented by a paralegal who works in the immigration law area. In this specialty, paralegals often interview clients and must keep in mind their plights along with the ethical responsibilities that must be shouldered as well. Let's see what our immigration paralegal observed. This is not a specialty for the faint-hearted or the misanthrope. The immigration paralegal may deal with much more than the timely filing of paperwork. One distinguishing feature of immigration work is our knowledgeable of intensely personal aspects of the client's life. We know his criminal record, the success and failure of his personal life, how much money he makes, and his dreams and aspirations. Some clients have a very laissez-faire attitude towards perjury and may invite the paralegal to participate without a blush. In America, said one client, you lie to your attorney. In my country, you cook up the lie with your attorney. Myers and Remen, sweet-talking clients and intransigent bureaucrats. 15 National Paralegal Reporter for NFPA. Chapter Review 12-12A. Chapter Summary. Introduction. To a large extent, public disfavor of the legal profession is based on misunderstanding. The role of the attorney in our system of justice. Attorneys often take unpopular cases and can find themselves in the middle of bitter disputes. Professionalism, your calling card. Regardless of the task, it is extremely important that you project yourself as a professional. Maintain a high level of integrity and competence to combat any negative assumptions that clients or the public may have about the legal profession. Although legal professionals are advocates and may engage on popular cases and clients, always being professional, no matter the circumstance, will correct public misconceptions and help you maintain the highest degree of legal professionalism. Hiring the firm. The attorney-client fee agreement retainer creates and formalizes the attorney-client relationship. An attorney may decide not to take a case because of conflict of interest, lack of merit, or the client's inability to pay fees. If the office decides not to represent the prospective clients, it should send them a letter of non-engagement. Context of interviewing in litigation. 1. The three main kinds of legal interviews are initial client interview, follow-up client interview, and field interview of someone other than the client. The initial interview sets up the foundation for the attorney-client relationship. This is where the initial facts of a case are developed. 2. The follow-up interview occurs after the initial interview. It is where additional information is gathered about a client's case. 3. The field interview occurs during the investigation phase of a case. It is where third parties are interviewed who may have important information about a client's case. Format of an intake memo. 1. Legal interviewing is designed to obtain facts that are relevant to the identification and eventual resolution of a legal problem. These facts are often reported in a document called an intake memo. 2. An intake memo contains the heading personal data. An intake memo contains the heading personal data, statement of assignment, the body of the memo, and conclusion. The body of the memo contains the pertinent facts of the case and is a significant part of the intake memo. The conclusion provides impressions of the interview and recommends next steps in the case, such as legal research or gathering of documentation, to name a few. What facts do you seek? Guides to the formulation of questions. 1. Guides to the questions to ask include instructions of the supervisor, a general understanding of evidence, procedural law, and substantive law, causes of action and defenses involved in the interview, checklists, fact particularization, FP, common sense, and flexibility. 2. Fact particularization allows the paralegal to explore specifics of a client's case and focuses on uniqueness. It is a fact collection technique, and fact particularization asks who, what, where, how, when, and why questions. 3. The types of details that should be extrapolated from fact particularization are date and time details, place and environment details, verification details, and analogies. Also, details on other participants and observed facts and inferences are critical to determine in the interview process. Visual demonstrations are helpful in particularizing the facts as well. 4. You are seeking levels of certainty and uncertainty when gathering facts. Gathering accurate is important and should be communicated to the client. 5. In an interview, the paralegal should be flexible and use common sense. Take copious notes so you can further instruction from your supervisor. What does the client want? Determining what the client wants often takes probing and a presentation of options by an attorney. Otherwise, the office might fail to identify client objectives. Assessing your own bias. Most of us are not fully aware of how our own bias affects our performance.
It is important to recognize bias and communicate that to the supervising attorney if you believe it will affect your performance in a case. Communication skills. Analysis of an interview. 1. The supervising attorney can help set the tone for an effective interview by introducing the client to the paralegal and explaining the latter's role. The professional interviewer strives to uncover facts that make the case of each client unique. 2. There are many ways to prepare for an interview, such as scheduling the interview at a convenient time, reading everything in the file, having supplies available, and preparing initial questions. 3. The seating arrangement should facilitate communication. The walls, desk, and overall appearance of the office should project a professional image. 4. The interviewer should go out to greet clients when they arrive at the reception desk. Always be appreciative of what the client does. Some small talk at the beginning of the interview can help decrease client tension. 5. Avoid making any promises of what the office can accomplish. Express empathy without being condescending or losing objectivity. Find out if there are any immediate concerns on the client's mind. Avoid legal jargon unless the client needs to know it and clear explanations are given. Briefly restate the purpose of the interview for the client. Let the client know why you are taking notes. Listen for clues to other problems the office should know about. 6. The following are the major kinds of questions an interviewer can ask, some of which overlap: open-ended overview, closed-ended, chronological, leading, corroborative, combination, and wrap-up. Avoid combination questions and multiple choice questions when interviewing a client. 7. One of the most important ways of building a relationship with the client is through attentive listening techniques, such as maintaining eye contact and occasionally repeating back what the client tells you. Ask questions that will uncover whatever observed facts helped lead to the inferences drawn by the client so that facts and opinions can be clearly identified and differentiated. 8. Factual comprehensiveness is achieved through fact particularization, FP, corroborative questions, probing, etc. The paralegal interviewer must be alert to potential ethical problems such as breaching confidentiality and giving legal advice. 9. At the conclusion of the interview, ask the client to read and sign needed forms. Find out if the client has any concerns not addressed during the interview. Tell the client what next steps are planned and make sure the client knows how to reach you. As soon as possible, make a note to the file that you conducted the interview. 10. Begin writing the report, intake memo, soon after the interview, making note of any personality characteristics relevant to working with the client. Improving your interviewing skills. To improve your interviewing technique, read literature and attend CLE seminars on interviewing. Seek the critique of others, try to observe others' interview, etc. The difficult client. Special sensitivity is needed when working with potentially difficult clients, such as those who claim to know all about the law, who are angry, who are demanding, or who lie. Every effort should be made to accommodate such clients while maintaining professionalism. But ultimately, the office may have to decide whether continued representation is feasible or ethically appropriate. Chapter Review 12-12A, Chapter Summary. Introduction. To a large extent, public disfavor of the legal profession is based on misunderstanding the role of the attorney in our system of justice. Attorneys often take unpopular cases and can find themselves in the middle of bitter disputes. Professionalism. Your calling card. Regardless of the task, it is extremely important that you project yourself as a professional. Maintain a high level of integrity and competence to combat any negative assumptions that clients or the public may have about the legal profession. Although legal professionals are advocates and may engage unpopular cases and clients, always being professional no matter the circumstance will correct public misconceptions and help you maintain the highest degree of legal professionalism. Hiring the firm. The attorney-client fee agreement retainer creates and formalizes the attorney-client relationship. An attorney may decide not to take a case because of conflict of interest, lack of merit, or the client's inability to pay fees. If the office decides not to represent the prospective clients, it should send them a letter of non-engagement. Context of interviewing in litigation. 1. The three main kinds of legal interviews are initial client interview, follow-up client interview, and field interview of someone other than the client. The initial interview sets up the foundation for the attorney-client relationship. This is where the initial facts of a case are developed. 2. The follow-up interview occurs after the initial interview. It is where additional information and gathered about the case. It is where additional information and gathered about a client's case. 3. The field interview occurs during the investigation phase of a case. It is where third parties are interviewed who may have important information about a client's case. Format of an intake memo. 1. Legal interviewing is designed to obtain facts that are relevant to the identification and eventual resolution of a legal problem. These facts are often reported in a document called an intake memo. 2. An intake memo contains the heading, personal data, statement of assignment, the body of the memo, and conclusion. The body of the memo contains the pertinent facts of the case and is a significant part of the intake memo. The conclusion provides impressions of the interview and recommends next steps in the case, such as legal research and gathering of documentation, to name a few. What facts do you seek? Guides to the formulation of questions. 1. Guides to the questions to ask include instructions of the supervisor, a general understanding of evidence, procedural law, and substantive law, causes of action and defenses involved in the interview, checklists, fact particularization, FP, common sense, and flexibility. 2. Fact particularization allows the paralegal to explore specifics. Fact particularization allows the paralegal to explore specifics of a client's case and focuses on uniqueness. It is a fact collection technique. And fact particularization ask who, what, where, how, when, and why questions. 3. The types of details that should be extrapolated from fact particularization are date and time details, place and environment details, verification details, and analogies. Also, details on other participants and observed facts and inferences are critical to determine in the interview process. Visual demonstrations are helpful in particularizing the facts as well. 4. You are seeking levels of certainty and uncertainty when gathering facts. Gathering accurate is important and should be communicated to the client. 5. In an interview, the paralegal should be flexible and use common sense. Take copious notes so you can seek further instruction from your supervisor. What does the client want? Determining what the client wants often takes probing and a presentation of options by an attorney. Otherwise, the office might fail to identify client objectives. Assessing your own bias. Most of us are not fully aware of how our own bias affects our performance. It is important to recognize bias and communicate that to the supervising attorney if you believe it will affect your performance in a case. Communication skills. Analysis of an interview. 1. The supervising attorney can help set the tone for an effective interview by introducing the client to the paralegal and explaining the latter's role. The professional interviewer strives to uncover facts that make the case of each client unique. 2. There are many ways to prepare for an interview, such as scheduling the interview at a convenient time, reading everything in the file, having supplies available, and preparing initial questions. 3. The seating arrangement should facilitate communication. The walls, desk, and overall appearance of the office should project a professional image. 4. The interviewer should go out to greet clients when they arrive at the reception desk. Always be appreciative of what the client does. Some small talk at the beginning of the interview can help decrease client tension. 5. Avoid making any promises of what the office can accomplish. Express empathy without being condescending or losing objectivity. Find out if there are any immediate concerns on the client's mind. Avoid legal jargon unless the client needs to know it and clear explanations are given. Briefly restate the purpose of the interview for the client. Let the client know why you are taking notes. Listen for clues to other problems the office should know about. 6. The following are the major kinds of questions an interviewer can ask, some of which overlap: open-ended, overview; closed-ended, chronological; leading, corroborative, combination, and wrap-up. Avoid combination questions and multiple-choice questions when interviewing a client. 7. One of the most important ways of building a relationship with the client is through attentive listening techniques such as maintaining eye contact and occasionally repeating back what the client tells you. Ask questions that will uncover whatever observed facts helped lead to the inferences drawn by the client, so that facts and opinions can be clearly identified and differentiated. 8. Factual comprehensiveness is achieved through fact particularization, FP, corroborative questions, probing, etc. The paralegal interviewer must be alert to potential ethical problems such as breaching confidentiality and giving legal advice. 9. At the conclusion of the interview, ask the client to read and sign needed forms. Find out if the client has any concerns not addressed during the interview. Tell the client what next steps are planned, and make sure the client knows how to reach you. As soon as possible, make a note to the file that you conducted the interview. 10. Begin writing the report, intake memo, soon after the interview, making note of any personality characteristics relevant to working with the client. Improving your interviewing skills. To improve your interviewing technique, read literature and attend CLE seminars on interviewing. Seek the critique of others. Try to observe others interview, etc. The difficult client. Special sensitivity is needed when working with potentially difficult clients, such as those who claim to know all about the law, who are angry, who are demanding, or who lie. Every effort should be made to accommodate such clients while maintaining professionalism, but ultimately the office may have to decide whether continued representation is feasible or ethically appropriate. Chapter Review. 12-12B Key Terms: deep pocket, declination, default, interviewee, intake memo, grounds, substantive law, fact particularization, FP, inferences, analogies, timeline, objective, contingency case, breach of contract, jargon, open-ended question, overview question, closed-ended question, chronological questions, leading questions, hostile, corroborative question, combination questions, multiple choice question, add-on question, wrap-up question. Chapter Review. 12-12C Review Questions. 1. In what kinds of law offices are paralegals likely to conduct legal interviews? 2. What is the purpose and reason for preparing a letter of engagement, retainer, and letter of non-engagement for a client? 3. What are the 3 kinds of legal interviews? 4. What is an intake memo? Name its 5 parts. 5. State 5 reasons why an interview can be ineffective. 6. What is fact particularization, FP, and the categories of questions for FP? 7. What is bias? And how can an interviewer's bias against a client interfere with effective interviewing? 8. What steps are needed to prepare for an interview? 9. What are some of the techniques and guidelines for beginning an interview? 10. What is the definition of the following kinds of questions? Open-ended, overview, closed-ended, chronological, leading, corroborative, combination, and wrap-up. 11. What are some of the techniques and guidelines for attentive listening? 12. How can an interviewer avoid ethical violations in an interview? 13. What are some of the techniques and guidelines for open-ending an interview? What are some of the techniques and guidelines for ending an interview? 14. List ways to improve your legal interviewing skills. 15. What are examples of some so-called difficult clients, and how should the office respond to them? Chapter Review 12-12D Assignments Critical Analysis 12.1 A potential client has contacted the office and wants to set up an initial interview. They tell you that their son slipped and fell on the neighbor's driveway while playing basketball with other neighborhood kids. They broke their ankle and sprained their wrist in the incident. The medical bills have been mounting up, and they want to sue the family. How would you prepare for the interview? List everything that you would do in preparation for the interview. Make a list of questions that you would pose to the new client. 12.2 Suppose that you are working in a law office where a client started yelling at you during an interview. How would you handle such a case? Explain what you would do. Assume that the only person in the office available to assist you is the receptionist, as everyone is either in court or out to lunch. 12-3 A. The instructor asks the class if anyone was involved in any way in a recent automobile accident. If someone says yes, this student is asked if they would be willing to be interviewed by another class member, whose job is to obtain as complete a picture as possible of what happened. At the outset, the interviewer knows nothing other than that some kind of an automobile accident occurred. The interviewee can make up any sensitive facts if they want to keep some of the actual events confidential. B. The instructor asks the class if anyone has recently had trouble with any government agency, like, for example, the post office or the Department of Motor Vehicles. If someone says yes, this student is asked if they would be willing to be interviewed by another class member whose job is to obtain as complete a picture as possible of what happened. The interviewer, at the outset, knows nothing other than the fact that the person being interviewed has had some difficulty with a government agency. The interviewee can make up any sensitive facts if they want to keep some of the actual events confidential. Project 12.4 Using any search engine, find sample interview checklists for the following type of cases. A. Automobile accident involving multiple vehicles and an injured pedestrian. B. Medical malpractice injury where sponges were left in the patient. C. Corporation where a client wants to set up a new company in their retail business. D. Collection case where client is being sued by credit card company for failure to pay. E. Domestic violence case where partner was battered by other partner, resulting in broken bones. Partner wants to file a civil action against the other partner. Chapter Review 12-12E Core Skills Assignments Core Skill Writing 12.5 When an office represents a debtor, one of the paralegal's major responsibilities may be to interview the client in order to write a comprehensive report on the client's assets and liabilities. Assume that your supervising attorney has instructed you to conduct a comprehensive interview of the client in order to write such a report. Assets are everything the client owns or in which the client has an interest. Liabilities are everything owed. They are debts. These are the only definitions you need. You do not need any technical knowledge of law to conduct this interview. All you need is common sense in the formulation of questions. Your instructor will role play the client in front of the room. It will be a collective interview. Everyone will ask questions. Take detailed notes on the questions asked by every student, not just your own, and the answers provided in response. You will have to write your individual report based on your own notes. Be sure to ask follow-up questions when needed for factual clarity and comprehensiveness. You can repeat the questions of other students if you think you might elicit a more detailed response. Any question is fair game as long as it is directly or indirectly calculated to uncover assets or liabilities. There may be information the client does not have at this time, such as bank account numbers. Help the client determine how such information can be obtained later. In your notes, state that you or another interviewer asked for information that the client did not have In your notes, state that you or another interviewer asked for information that the client did not have, and state what the client said he or she would do to obtain the information. To achieve comprehensiveness, you must obtain factual detail. This means that you go after names, addresses, phone numbers, dates, relevant surrounding circumstances, verification data, etc. In short, you want fact particularization, FP. See Exhibits 12-4 and 12-5. The heading of your report will be as follows: Office Memorandum. 2. Name of your instructor. From your name, date you prepared the report. RE, comprehensive interview of. Case file number. Make up the case file number. The first paragraph of your memo should state what your supervisor has asked you to do in the memo. Simply state what the assignment is. Organization of the data from your notes is up to you. Use whatever format you think will most clearly communicate what you learned from the client in the interview. Use clear headings to help the reader grasp the volume and variety of facts covered in the memo. Core skill research 12.6. Our facts at the beginning of the chapter. The client became angry and agitated during the interview. Research some of the techniques that can be employed to manage an irate client. Prepare a memorandum to the supervising attorney stating what occurred during the interview and how you managed the situation. Make recommendations of your impressions and whether the firm should take the case. Make recommendations of your impressions and whether the firm should take the case. Improvise the facts if necessary. Core skill ethics 12.7. Miss Jones is being sued by Mr. Jones for divorce on the ground of adultery, which she has denied. Miss Jones is the client of your office. Thus far, your investigation has revealed that there is considerable doubt over whether Miss Jones did in fact commit adultery. During a follow-up interview with Miss Jones, she tells you that she is a prostitute. She asks you not to say anything about this to anyone because she has just started therapy for drug addiction. What should the paralegal do? Identify ethical problems that are likely to result from the various responses the paralegal could make to this request by the client. Core skill computers 12.8. Prepare a template intake case sheet for A, automobile accident case, B, medical malpractice case, C, incorporation of new business. Hint: search online to find examples of these types of intake case sheets to create the template you want to use. Core skill collaboration 12.9. In this exercise, fact particularization FP will be role played in class. See exhibits 12.4. See exhibits 12-4 and 12-5. One student will be selected to play the role of the client and another, the role of the paralegal interviewer. The rest of the class will observe and fill out the FP scorecard on the interview. The FP scorecard is at the end of the chapter. Instructions to interviewer. You will not be conducting a complete interview from beginning to end. Instead, you will be trying to particularize a certain fact that is given to you. Go through all the categories of FP outlined in Exhibit 12-5. Use any order of questioning you want. Probe for comprehensiveness. See also Exhibit 12-10 on comprehensiveness. Your instructor will select one of the following facts to be used as the basis of the interview. A, I was hit in the jaw by Mary. B, he neglects his children. C, I have not been promoted because I am a woman. D, the computer system the store sold me is useless. E, I am buried in debt. After the client makes one of these 5 statements to you, your opening statement to the client will be, tell me what happened. Then use the process of FP, fact particularization, to particularize the statement. Instructions to client. Instructions to client. The interviewer will ask you, what happened? Make one of the 5 statements above as selected by the instructor. Then the interviewer will ask you a large number of questions about the statement. Make up the answers. Ad-lib your responses. Do not, however, volunteer any information. Answer only the questions asked. Instructions to class. Observe the interview. Use the FP scorecard to assess how well you think the interviewer particularized the fact. Do not, however, focus on the scorecard while the interview is underway. Peruse the scorecard briefly before the interview begins and close your book until the interview is over. Concentrate on the interview itself. The FP scorecard for assignment 12.9 is at the end of the chapter. 12.10. The following exercise involves an interview role played in class. After watching this interview, you will be asked to deduce some principles of communication for interviewing. Legal interviewing. Communication score. Legal interviewing communication score, LICS. In this exercise, 2 students will role play a legal interview in front of the class. The rest of the class will observe the interview and comment on it using the LICS at the end of this chapter. Instructions to client. You will role play the part of a client. A month ago, you sprained your back while lifting a printer and carrying it from one room to another. You are an accountant. When you came to work that day, you found the printer on your desk. It did not belong there, and you did not know how it got there. You decided to move it to another desk. That was when you sprained your back. You have come to the law office for legal advice. You have already seen an attorney in this office who has agreed to take your case. An interviewer has been assigned to conduct an interview with you to obtain a complete picture of what happened. This interview will now be role-played in front of the class. The basic facts involve the accountant and the printer. You can make up all other facts to answer the interviewer's questions. Make up the name of the company for which you work, the details surrounding the accident, etc. You can create any set of facts as long as your answers are reasonably consistent with the basic facts given to you above. Instructions to interviewer. You will play the role of the interviewer in the case involving the sprained back. You are a paralegal in the office. All you know about the case thus far is that the client's back was injured in a work-related accident. You have been assigned to interview the client for detailed information about the client and about the accident. Start off by introducing yourself and your role. State the purpose of the interview, then proceed to the questions. Take notes on the client's answers. You do not need to know any law in order to conduct the interview. Let common sense be your guide. Your goal is to compile as comprehensive a picture of the facts as you can prompt this client to convey. Consult the material in Exhibits 12-4 and 12-5 on fact particularization, FP, as you prepare and formulate questions. Be sure to listen carefully to the answers so that you can ask appropriate follow-up questions that seek more details on the facts contained in the answers. The class will observe you in order to assess the manner and content of the interview. The class will observe you in order to assess the manner and content of the interview. A good deal of constructive criticism may develop from the class discussion. As you listen to the criticism, try to be as objective as you can. It is difficult to conduct a comprehensive interview and probably impossible to conduct one flawlessly. For every question that you ask, there may be 10 observations on how you could have. For every question that you ask, there may be 10 observations on how you could have asked it differently. Hence, try not to take the comments personally. Instructions to class. You will be watching the interview involving the sprained back. You have 2 tasks. 1, read through the Legal Interviewing Communication Score, LICS, at the end of this chapter. Then close your book so that you will give your complete attention to the interview. After the interview, fill out the LICS form. The teacher will ask you to state the total score you gave the interview or to submit this score to someone who will calculate the average score from all students' scores. 2, identify as many do's and don'ts of interviewing as you can. If you were writing a law office manual on how to interview, what would you include? What guidance would you give an interviewer on taking notes during the interview? Asking follow-up questions, maintaining eye contact with the client, etc. After you observe the interview, discuss specific suggestions on what an interviewer should or should not do. Ideas will also come to mind while you are filling out the LICS form. 12.11. Form a circle of chairs with a single chair in the middle, or if an online class, the instructor will provide guidance and follow the general instructions in the exercise. If in a physical classroom setting, the student sitting in the middle will play the role of the client. The students in the circle, numbering about 10, will be the interviewers in rotation. The instructor will ask one of the students to begin the interview. As the student runs into difficulty during the interview, the student to the right picks up the interview, tries to resolve the difficulty, and then proceeds with the interview. If this student cannot resolve the difficulty, the student to their right tries, and so on. The objective is to identify as many diverse ways of handling difficulties as possible in a relatively short period. No interviewer should have the floor for more than a minute or 2 at any one time. The student playing the role of the client is giving specific instructions about how to play the role. For example, sometimes they are asked to be evasive, other times demanding. The client should not overdo the role. However, the student should respond naturally within the role assigned. Here are 4 sets of instructions for this interview in rotation. A. The interviewer greets the client and says, "I am a paralegal." The client is confused about the definition of a paralegal. The interviewer explains the client is insistent upon a comprehensive definition that can be understood. B. The client is being sued by a local store for $750 in grocery bills. The client has a poor memory and is having difficulty remembering what was or was not purchased at this store. Where the client has shopped for over a year, the interviewer must think of ways to help them remember. The client wants to cooperate but is having trouble remembering. C. The client wants to sue an auto mechanic. The client gives many opinions, conclusions, and judgments, such as the mechanic is a crook, I was their best customer, or the work done was awful. The interviewer is having difficulty encouraging the client to state the facts. Observed data underlying the opinions. The client insists on stating conclusions. After each exercise, the class should discuss principles, guidelines, and techniques of interviewing. The job search 12.12. In assignment 12.5, you prepared a memo based on an interview of a client concerning assets and liabilities. Rewrite this memo so that it can be a writing sample for your portfolio when you are looking for employment. The memo must have no spelling or grammar errors. The paragraphs must be skillfully organized. Find 2 individuals who are willing to evaluate the memo. They do not have to be paralegals or attorneys. You want an evaluation that covers spelling, grammar, paragraph structure, and overall organization and clarity. Rewrite the memo based on their critiques. Chapter Review 12-12F. Portfolio Binder Assignment. Your supervising attorney has asked you to interview a client. You know some basic facts. 1. The client's name is Marquise Thomason. 2. Marquise is male and 58 years old. 3. Marquise had an interview for a job and was escorted into the conference room. 4. After sitting in a chair for approximately 15 minutes, the chair collapsed and Mr. Thomason fell backward, hit his head, and fractured his arm. 5. Marquise had a previous back injury. 6. Marquise may have extensive injuries. 7. Marquise has medical bills. Prepare the interview questions that you would ask Mr. Thomason. Create responses to your questionnaire to Mr. Thomason. Think about the information you want to obtain from the interview, such as medical bills, hospital stays, prognosis, and future medical expenses. Think about the conditions of the chair and other furniture within the conference room. Consider the manufacturer of the chair and its age. From the responses to the questionnaire, create an intake memorandum to your supervising attorney with recommendations for next steps in the case. Place in your portfolio binder. Effective in obtaining date and time details. Effective in obtaining place and environmental details. Effective in obtaining details on other participants. Effective in finding out where the client's statements fall on the spectrum of certainty. Effective in seeking verification details. Effective in using analogies to obtain greater detail. Effective in obtaining miscellaneous details. Weak in obtaining date and time details. Weak in obtaining place and environmental details. Weak in obtaining details on other participants. Weak in finding out where the client's statements fall on the spectrum of certainty, weak in seeking verification details, weak in using analogies to obtain greater detail, weak in obtaining miscellaneous details. Following the interview, put a check on the appropriate number for each of the preceding categories of assessment. A 5 score means you thought the interview was very precise or effective in fulfilling the goal of the particular FP, fact particularization, category being assessed. A 1 score means the opposite. Also make notes of questions you think the interviewer should have asked. These questions and your scores will be discussed in the class after the interview. Legal Interviewing Communication Score, LICS, to be used with assignment 12.10. How to score. You will be observing the role-playing of a legal interview and evaluating the interviewer on a 100-point scale. These 100 points will be earned in the 4 categories listed below. The score is not based on scientific data. It is a rough approximation of someone's oral communication skills in a legal interview. A score can be interpreted as follows: 90 to 100 points, outstanding interview; 80 to 89 points, good interviewer; 60 to 79 points, fair interviewer; 0 to 59 points. A lot more work needs to be done. Of course, the LICS does not assess the interviewer's ability to write an intake memo for the file. See Exhibit 12-3 and the discussion of the intake memo earlier in this chapter. Category 1, Role Identification. On a scale of 0 to 5, how well did the interviewer explain their role and the purpose of the interview? A 5 score means the interviewer took time to explain clearly what their job was in the office and what they hoped to accomplish in the interview. A low score means the interviewer gave little or no explanation or mumbled an explanation without being sensitive to whether the client understood. Category 1 score. Category 2, factual detail on a scale of 0 to 80. How would you score the interviewer's performance in asking enough questions to obtain factual comprehensiveness? How well was FP, fact particularization, performed? An 80 score means the interviewer was extremely sensitive to detail in their questions. A low score means that the interviewer stayed with the surface facts, with little or no probing for the who, what, where, how, when, why details. The more facts you think the interviewer did not obtain, the lower the score should be. Category 2 score. Category 3, control. Control. On a scale of 0 to 10, how would you score the interviewer's performance in controlling the interview and in giving it direction? A 10 score means the interviewer demonstrated excellent control and direction. A low score means the interviewer rambled from question to question or let the client ramble from topic to topic. Category 3 score. Category IV, earning the confidence of the client. On a scale of 0 to 5, how would you score the interviewer's performance in gaining the trust of the client and in setting them at ease? A 5 score means the interviewer appeared to do an excellent job of gaining the trust and confidence of the client. A low score means the client seemed to be suspicious of the interviewer and probably doubted their professional competence. The more the interviewer made the client feel that they were genuinely concerned about the client, the higher the score. The more the client obtained the impression that the interviewer was just doing a job, the lower the score. Category IV score, total score.